Hey, Chrissy.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anybody since we met yesterday? Yes. Everyone said yes or nodded affirmatively. Was everyone able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Everyone said no. So, Mr. Foreman, with that, we're going to send you back out to deliberate.
All rise for the court, please.
Jimmy?
Jurors, follow me.
Excuse me?
Please be seated. The court is in session.
So, I've been sending a note in at 4 o'clock, so I would like counsel here at 4 o'clock. All right, so if you just plan on being here at 4 o'clock, it would make it easier in case the jurors want to go home.
Perfect.
So, all right, Ms. Giannetti, it wasn't until I was here that I noticed you were not in the courtroom.
They held me downstairs, Your Honor. I think the jury was being brought in, so.
Okay. No one told us otherwise either, so.
Understood.
All right, thank you.
All rise. Court stands at recess to exit the courtroom.
So,
Okay. No one told us otherwise either, so.
understood.
All right, thank you.
All right. What's the into recess to exit tomorrow?
So we've got day 3 of deliberations now officially underway in Dedham, Massachusetts. There's that famous ceiling fan. We keep saying everybody recognizes it because of the high-profile nature of this case. So we're going to pop up the verdict clock and show you the time counting. We know that up until this point, they've done over 9 hours of deliberation work, starting on Friday, going into yesterday, and now today is day 3. Let's go outside of the courthouse together now. Get you a live update from Court TV. Crime and Justice correspondent Matt Johnson, who is outside gauging the mood of what's going on. Matt, good morning to you.
Yeah, good morning, Julie. So in real time, just a few minutes ago, this defendant, Karen Reed, walked down the steps of the courthouse here behind me in Dedham Square. She made her way to her vehicle and she exited. It didn't appear that she answered any questions of the media. This is one of 2 of the times of the day where she usually does address questions and gives some answers. But it appears that she did not today, which could be a change. But we had our Grace Wong, who is our senior producer over there, so we'll find out that answer very shortly. But it appears that there is no issue with this jury. They're back deliberating. Yesterday, they ended the day, day 2. That was their first full day of deliberations at 9 hours and 9 minutes. The verdict clock is back on your screen. The first day, they only had about 2 hours worth of deliberations, and they have so much to go over. You have to consider this was 8 weeks of testimony, nearly 50 witnesses that had taken the stand, and that lengthy verdict form. But the crowd out here in front of the courthouse, it appears to be a little bit smaller than it was yesterday, but still much larger than it was during the course of this trial, Julie.
Right, Matt. We're looking at some video. This was shot just a short time ago. The defendant and her lawyers walking into the courthouse. Matt, is it much quieter this time around than it was last year at this time, hearkening back to when you were on the ground for trial 1?
Yeah, well, the rules are different, and we've been talking about that quite a bit, right? We have the supporters that are out here, including yesterday, where we had hundreds of supporters that were lining up the streets here. And they were all just giving a peace symbol or a love symbol in sign language. At least that's what they told us. And they are being encouraged not to shout or scream or use blowhorns or have signs in this restricted buffer zone. But the rules are a little bit more relaxed so that they can be here and assemble quietly. So that's the big difference, I would say, Julie. This morning, it is a little bit more of a quiet tone than it was yesterday even, because there are just fewer people that I've seen. Yesterday, a lot of people took time off. They traveled this way to this tiny community that remains still divided.
Sure. Matt, if we could focus on the verdict slip for a moment, I would love that. For anybody who might have missed it, the defense team, we understand, made a motion to try to amend it. You were there for that. Could you explain to us what exactly they were wanting to do with it?
Yeah, this was a last-minute motion that was filed yesterday on day 2 of our verdict watch here in Dedham. And the defense team had filed a motion, much like we had seen prior to deliberations and also last year, very similar. They were asking for more not guilties to be put on the slip because they say that it appears to be confusing for the deliberating jury, which was some of the reports coming out of some of the jury members that alleged that they had reached a not guilty on 2 of the charges last year, but they didn't quite know how to fill out the form, and then they were never polled at the end. We all know that we've covered it, and that challenge was taken all the way up to the high court in the Commonwealth of Massachusetts, and it was upheld. Beverly Cannone, the judge in this case, as she was the last one, denied that motion. We just put it on your screen right there. She says that this slip follows with Massachusetts state law and the way that the state legislature has laid out the charges.
So, Matt, just
and
so
here's reaction from
sorry.
Karen Reed on that.
Oh, okay.
Yeah. So I wanted to play that reaction from Karen
do.
Reed on that moment yesterday.
Steps in this. Yeah, they're coming. In a response to the
There was
judge
no
denying the
preparation
verdict
this weekend. What did you do for the weekend now that you don't have to prepare anymore?
We wrote a motion to reconsider the verdict slip that was just denied without a hearing.
You want more boxes added to that verdict
Yes.
slip, the lesser included.
Yes.
Can you explain why that's important to you?
I think what happened last year with the same verdict form explains that the jurors themselves found it confusing, and it said as much. So we just wanted to avoid that again, and apparently the jurors not concerned. So we'll just move forward and we don't.
Overall feelings heading into today, Karen?
I feel well. I feel strong, and the jury will do the right thing.
So this is the third or fourth attempt overall that the defense team has asked for an amended verdict form. But again, Judge Beverly Cannone is just following the guidelines of the law with anyone that would have been charged with these similar charges.
Right. That's important to note, Matt. Thank you for that. That this is a standard form. It's standard in the Commonwealth of Massachusetts. No matter what district you're in, every defendant is going to have this kind of form if it's this kind of case. So important to note. And just for clarity, so Judge Cannone did the same thing at Trial 1 that she did just yesterday in Trial 2 in denying that request to make any special amendments.
Yes, that's correct, because prior, I think it was during deliberations, is when the defense team brought it up last year that they felt like the verdict form was too complicated. They were concerned about it. They brought up those concerns. Judge Cannone took it under advisement. No changes were made. And then this year they brought it up again before deliberations. And then yesterday was that last-minute motion that was filed, which was denied without any sort of arguments about it.
Mm-hmm. Gotcha. Okay, so at least we can see the judge has been consistent, doing the same thing each time, and as you noted, ended up ultimately prevailing with all the appeals and the questioning that was done with her decision last time. Matt, in terms of anything from this jury, have we heard a peep from them, even a question?
Right, and it's just so admirable that we have this jury that has been a part of this process for nearly 12 weeks for some of them, because remember, jury selection, we were standing here for it all, that took a 3-week process, and then we had 18 selected, 9 men, 9 women, and then they used a lottery system to select those 6 alternates. So that leaves us with, out of the 12, 7 women and 5 men that are the deliberating jury here in Dedham. And we have not heard any sort of questions or anything being presented to the judge, any concerns, which might be a good way, no matter which way you're thinking that this jury might be leaning. But last year we had several questions, including, can we go to lunch? Can we go home for the day? And then the more serious ones where, we are deadlocked and we don't know how to resolve this. What should we do, Judge? And that was 2 or 3 of those.
So we'll see if we get any of that today. Matt Johnson, thank you so much for the live update. Be safe, my friend. We'll talk a little bit later this morning. Here's what we're going to do. We're going to hit our first break of the hours. The clock continues ticking. We're at 9 hours, 18 minutes of deliberations. And when we come back, we've got the best portions of testimony from John O'Keefe's dear friend and case witness, Carrie Roberts.
Brutal murders of 4 University of Idaho students.
Oh my God, this doesn't happen here.
Detectives arrested 28-year-old Brian Kohlberger.
You could tell there was some off about him.
He was stalking them. He was hunting them.
Forget about motive. We don't even have a connection.
This trial will be on Court TV.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
Johnny was unbelievably generous. He was unbelievably loyal. Again, as John Jackson had mentioned, once you're in Johnny's orbit, you were there permanently.
He also was taking, one of his fellow police officers to cancer treatment, and no one ever knew. No one ever knew. He just never would do things for his friends and never ask for anything in return, and that is just really who he was.
But at the end of the day, Johnny's not here with us anymore. For those closest to him and for many others, we're going to miss him tremendously.
It's great to hear from John O'Keefe's loved ones. He is missed, and he is not forgotten. There's been a lot of noise with this trial, a lot of debate, but let's not forget the life that was lost. We know that John is deeply missed and deeply loved by his family and his friends, 46 years old at the time that he was killed. And this trial is about him. Make no mistake about it. It's not about the protesting going on outside. It's not about the defendant. It's about the victim. That is why these charges were brought, because there was a death. Let's take a live look inside the courtroom right now. The judge has sent the jury to the deliberation room, and we see the fans spinning on the ceiling. So our cameras are positioned there ready to go if we hear any questions or if a verdict happens to be arrived at. We're going to bring it to you live immediately here on Court TV. In the meantime, we're going back through some of the most key testimony that members of the jury might be mulling over right now. I want to show you some testimony from John O'Keefe's dear friend, who became a witness in this case because Karen Reed involved her in it when she woke her up in the middle of the night, back when that blizzard was happening on January 29th, 2022.
I was looking on both sides of the road in case he was walking home.
Did you see Miss McCabe searching?
Yes, she was looking out as well.
Describe a little detail about what you saw Miss McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat, and then she would be in between Jen and I, in the back seat, and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
There was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was, because she was in the back seat.
Okay. As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white-knuckling because it was getting slippery. Karen wouldn't put on her seatbelt, because she was in between us again the whole ride, and then sitting back. But she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. And I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, at some point Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about, but apparently Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
Objection.
I'm going to allow it.
So as you approached Fairview, tell us what happens.
As we approached Fairview at the house, you mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's now kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay, what happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is, so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
What do you think Carrie Roberts' testimony did for this case? Let's bring in our guest now. I'm so pleased to have on the show with me this morning, domestic violence expert and former law enforcement officer Claudia King, and the former head of the homicide unit in Norfolk County, Massachusetts, attorney Rick Grundy. Good morning to you both. Let's focus in on what we got from Carrie Roberts in this case. A lot of emotion, eyewitness testimony at the most critical moments, perhaps, of the event in question. Claudia, how do you think that the jury received her testimony?
You know, I think she came across as very relevant, very relative to that moment when Karen supposedly first saw John. And I think the jury really picked up on that, you know, there's low visibility overall because of the snow, and suddenly Karen sees what other people see as just a lump of snow, but knows it's John. And so I think that's an opportunity for the jury to really say, well, how did she know he was there? If she thought she left him inside, she thought she left him at the waterfall, you know, all these different places, why suddenly is this lump in the snow definitely him? Why does she know that all of a sudden? So I think the jury would have really keyed in on that point from Carrie. I think, you know, she came across as very honest, truthful, and she had a lot of great information to share.
Right, Claudia, well said. Rick, turning to you now, how key do you think Carrie Roberts is to this case? Noting something else that I thought Hank Brennan really hit home in the close well when he told the story about how Karen Reed called Jen McCabe first and said, Jen, John never came home. I left him at the waterfall and don't know where he went. And Jen said, well, no, you didn't leave him at the waterfall. I saw you outside of the house at 34 Fairview. You drove in front of the house and click. Karen Reed hung up the phone, and then she calls Carrie Roberts, according to the evidence, and says, Carrie, John is dead. He got hit by a plow. And Hank Brennan argued, well, that was Karen Reed's way of substituting her big 6,000-pound Lexus SUV. Rick Grundy, what do you say?
Good morning, Julie. I put Ms. Roberts in the category of all-star with respect to the prosecution witnesses in this case for so many reasons. One is just the ambience of it. It's one of the few witnesses presented who could really present Officer John O'Keefe to us as a friend and a person and a uncle to two children that he brought in, etc. And what a wonderful individual he was. So that was just kind of gloss to it. But then the substance is crucial, for all the things that you just mentioned. She's kind of the the connection for these various stories. And clearly, Prosecutor Brennan made a point of, I am going to at least partially, and I think in a large part, convict Miss Reed on her own words. And this was exactly what you want to do in a case like that. The building of an alibi, the building of a story, the building of removing myself from something I know happened. And I think it tracks perfectly. And then finally, her presentation. And again, I know I've said it many times, but the message is only as good as the messenger. And you can see her, not just in her words, not just in her answers, but in her very demeanor. This is gut-wrenching for her. Not gut-wrenching because she's searching for the truth. Gut-wrenching because every second she's up there, she's talking about the death of a friend and how much it pains her to be going through this. And she was one of the few witnesses that was really in a position and did translate that to the jurors.
Excellent assessment, Rick. Boy, thank you both so much for that. We have more questions for you. Stand by kindly, please. What we're showing here was some video just a short time ago. The defendant in the courtroom would not make eye contact with any of John O'Keefe's family or loved ones who are in that jury box. We see a sea of blue there in the box supporting John. They are very confident. I spoke with two of them yesterday about the support that they have for their loved one, John O'Keefe. And their supporters may not be the loudest ones. They may not be out there wearing matching T-shirts or with bullhorns, but they are very confident in the people that have quietly offered them love and support and encouragement for the loss of John O'Keefe. We'll hit a break. When we come back, more coverage of the verdict watch of the case of Massachusetts versus defendant Karen Reed.
Every day we kind of go into what's happening in court today, but now that it's over, we start to think about him again in this way that we were unable to during the trial, and it's just such a emotional day, emotional feeling for it to be in the hands of the 12 jurors.
That was John O'Keefe's dear friend, Jackie Dugal, and John's cousin, Renee Rizzitano. They were on the program with me yesterday morning. They have experienced an immeasurable loss with the death of John O'Keefe. They are both there at the courthouse today. I saw them when we were filming a short time ago, going in with John's family, all of the loved ones sticking together, supporting him. It was a little sea of blue that marched in together this morning. And one of those supporters, no doubt, is John's dear friend, Carrie Roberts. Here's that video I was just talking about where you see all of those loved ones, people who we've seen time and time again supporting John. And they may do it more quietly in a more reserved way, but no doubt the support is there. John's brother, Paul O'Keefe, John's father. There's Jackie there with the blue pants. She just passed by. And I saw Renee in that video as well. They're all there supporting John O'Keefe and hoping and praying for justice. One of those people who has been praying for justice for her dear friend is Carrie Roberts, one of John's best friends for many, many years. And she became a case witness because of the defendant's actions, not because of John's actions, but because of the defendant's. The defendant woke her up in the middle of the night, told her that John was dead, told her that John got hit by a plow. And Carrie Roberts went out in that blizzard to find her friend. Let's go back in and watch some more of her testimony together now.
I want you to describe to the jury your best memory of what it looked like.
Karen pointed out and said, look, my taillight. And she said, do you think I hit him? And I said, no, I don't think you hit him. What are you talking about? Let's just go find him. But the taillight itself, the piece was missing. And as you got closer, there's a metal sort of square, and one of the pieces was sort of sticking out. And I only remember it because I thought if someone walks by that, they're going to catch their jacket on it.
How long of a time did you have to actually look at the taillight?
Under a minute.
How close were you to the taillight when you looked at it?
I was in front of it. I could see.
And when you talked about the taillight, you said a piece was missing. Is this the left side or the right side of the Lexus that you saw the piece of the taillight missing?
It was the right side, so it was the passenger taillight.
May I approach?
Yes.
Should I remain, Your Honor?
Sure.
Thank you. May I recognize what is in that photo?
That is Karen's SUV.
Is it similar or a fair and accurate depiction of how you saw the vehicle that morning?
Without the snow, I can't be positive, but this square piece was missing, as is in this picture.
The photograph you look at is not the car in the snow in the driveway the day you saw it.
Correct.
Putting that aside, is that a fair and accurate depiction of the damage that you saw to the right rear taillight of Ms. Reed's car that morning?
Yes.
I move to introduce this as an exhibit, please.
Any objection?
No objection.
Okay. Exhibit 13.
Thank you. With the court's permission, I'd like to publish Exhibit 13.
Sure.
Mr. Roberts, I'm going to ask you to take a look at the photo that you just described. Do you see the white area in that photograph?
Yes.
Is that where the taillight had missing part?
Yes.
And where was the metal in relation to that white part that you see?
If you look at the white part, it's the upper left. It's sort of like a rectangle, but it's vertical, sort of.
And that's the metal part that you were concerned about?
Yes, one of the side, it's almost like an encasement, but the right side, I think it was the right side, was sticking out a little bit, like out from the car toward me.
Did you express any concern about the metal sticking out?
Yes, because I thought at that height it could clip someone's coat or something if they were walking by.
You mentioned the defendant asked you if you thought she hit somebody.
Correct.
How many times did she ask you that?
She asked me that in the driveway. How many times? She said, do you think I hit him? Do you think I hit him? And my answer was, no, I don't think you hit him. I'm sure you hit something because your taillight's broken, but I don't think you hit him. Why would I think that?
Did you have any reason to think at that point that she hit anybody?
No.
Did she ever repeat that phrase or question in the same or similar manner again that night?
She did at the scene where we found John.
Before or after you found John?
After we found John.
Okay. So we'll get to that then. Could we please take that picture down, Ms. Gilman? How far of a ride is it from Meadows to Fairview?
I don't know, maybe 8 minutes.
So when you left John's house at Meadows and you traveled to Fairview, you said you were driving.
Yes.
Was there any comments or conversation from the defendant on that ride?
There was talk of Bella's mom, who lived near Jen's sister. There was talk, and I said, where is Fairview? And Jen said, it's off of Chapman, so it was near Spring Lane. And I knew of somebody previously that John had dated on Spring Lane, so I brought it up thinking, could he have gone there if he was walking home? I don't know. I didn't know where he was or why he was missing.
Describe the mood in the car.
Well, it was scary driving, and Karen was, frantic, and she was yelling. I don't even remember at this point what she was yelling, but she was yelling. She had an elevated voice. She would be in between us while I was driving, and she would sit back in the back seat, then be in between us.
Did you have any words with Miss Reed?
I told her to shut up several times because I was trying to drive, and I couldn't concentrate. I told her to sit back and buckle up because it was bad driving. I didn't want to get into an accident and her not have a seatbelt on.
How often was the yelling on the way to Fairview?
Oh, several times. It was like you couldn't control her, and I was trying to drive in a blizzard.
You went down Spring Road before you get to Fairview?
No, Spring Lane is before Fairview off of Chapman.
And did anything remarkable happen on Spring Lane?
I'm sorry?
Anything remarkable happen on Spring Lane?
No.
More of the same?
Yes.
Now, you mentioned yesterday that when you got to Fairview, the defendant began kicking your door.
Yes.
When you looked out, you didn't see anything.
I did not.
And at some point, you ran over to where Miss Reed was.
Yes.
Okay. Tell us what your first observations are when you get close to the defendant.
Well, it was a shape of a body, like the length of a body, shape of a body. She ran over, and I said, oh my God. I jumped out of the car. I ran over, and she was lifting up his shirt to try and warm him, I guess. So I went over to his head, and I began to dig his head out of the snow.
Can you take us back and describe for us what you're seeing?
His body was completely covered, but his head was completely covered. So I started to dig around his face and his eyes, and his left eye was fine, but his right eye looked like it was huge, like he had something happen to it. And after that, I told Karen to get off him. We were going to start CPR. I had been certified at work through the American Red Cross, so I knew chest compressions were more important. So I started to do chest compressions, and I yelled to Jen and told her to call 911. Karen was trying to do mouth-to-mouth. I don't know if she knew what she was doing, but I knew chest compressions were more important, so I concentrated on that. I yelled for Jen. I carry blankets. I have 2 kids, so I carry blankets in the car, so I yelled to Jen to get the blankets. I don't know what I thought I was doing with blankets, but I wrapped them around his head, just thinking we're trying to warm him up. He was covered in snow.
When you first ran over, you mentioned that his head was covered in snow. Was his head fully covered in snow?
Yes.
When you looked down, could you see who it was at first?
At first? No, I had to dig him out.
When is it that you realized that this was your friend John?
When I cleared the snow off his face.
Did you feel his skin?
Did I feel what?
His skin.
Yes.
Okay. And could you tell us how it felt?
It was cold. like he had been there in the elements for a while.
You know, looking back on her testimony, it makes me remember when I saw it happening live, and I kept thinking, I could just feel how painful this was for her. To me, everything, just the way she spoke, all of it, her eye movements, the way she told the story, you could just tell this is somebody who's been left in a great deal of pain, experiencing a trauma. Make no mistake about it, Carrie Roberts went through a trauma. So did Jennifer McCabe, and what they were dragged into on that dreadful night. We're gonna hit a break. When we come back, we're gonna watch the testimony of John O'Keefe's mom. What a strong, classy lady she is. It's remarkable, the strength and the resilience that she has exhibited throughout not just one, but 2 trials in a quest to get justice for her son. That's next.
Coming soon to Court TV.
It's the biggest story that we're covering.
These murders have shaken our community.
He is the boogeyman.
So many eyes have been on Donna Adelson from the beginning. It's terrible. A social media sensation, now a suspected killer.
Why do you have something against me?
She wrote a children's book about her husband's death. Now she's accused of killing him.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.
I want to show you what took place just a couple of moments ago while we were in our commercial break. The members of the O'Keefe family, the friends, the supporters, all wearing blue, escorted out of the courthouse to go continue hoping, praying that they get justice for their loved one, John O'Keefe. And then on the other side, you see a mob of media. And I'm going to have to ask my producers, because I didn't see if there's anybody in that circle of media. Did we see? Okay, I'm being told they say that Karen Reed's team is underneath those boom mics that Karen Reed and her lawyers. Boy, isn't that interesting? So we see the media all crowded around defendant Karen Reed and her team, but not filming the O'Keefes and their supporters. Here's what we want to do now. We want to shine a spotlight on John's mother, Peggy O'Keefe, and the resilience and the courage that she's displayed going through these 2 trials. She was not a witness in the first trial, but she was called as a witness in the second trial, and what she testified to was important. Remember, there was a little bit, I said just a little bit of interaction that she had with the defendant that morning that John was killed. Let's watch.
When she called you that morning, do you remember the conversation?
Yeah, she said John was found in a snowbank, and I didn't understand, which I said, what do you mean found in a snowbank? She said, they found him in the snow. They don't know what happened. She says he's brought up to the Good Samaritan Hospital. So she says, I'm gonna come get you and Papa, because I don't want you to drive. And I says, we can drive there. We both have 4-wheel drives. And she says, no, I'm coming. So she came to get us. And it took a while to get there because the snow was bad. And in the meantime, I had called one of my nieces to find out, because one of my other nieces worked at Good Samaritan. I just wanted to know if she could find out anything about it. And I just couldn't get a hold of her. So when we get up there, they told us to sit in this room, and they would bring us down shortly. So finally they said, okay, you can go down. So we started walking down the corridor, and as I'm walking down, I hear Karen Reed yell, Peg, is he dead? Is he dead, Peg? Peg, is he dead?
Oh my, doesn't your heart break for her? Let's bring in our guest, domestic violence expert, former law enforcement officer Claudia King is with us, and the former head of the homicide unit in Norfolk County, attorney Rick Grundy. Claudia, I want to go to you here, please. I know we have to let you go in just a couple of minutes. Tell me, Peggy O'Keefe, your thoughts on her testimony and what the jury took away from it.
What an incredibly strong, classy lady. It was absolutely heartbreaking watching her testify. But I think, again, she had some relevant information to provide. And I believe that the jury heard that. You know, I was glad that she didn't have to testify in the first trial. It was heartbreaking. I'm sure it was very difficult for her. But if she plays a role in getting John justice, I think that will go a long way in hopefully helping her to heal as she processes this enormous tragedy that she's been going through for 3+ years now.
Right, Claudia. And we just have a few seconds, but she is a key witness, too, in a way, because the morning of this event, Karen Reed made some statements and then essentially ran away from the house, didn't stick around to console her, or if there was a big mystery, as her team is saying now, didn't stick around to solve it with Peggy O'Keefe or try to look for whomever may have allegedly done this. We will continue our coverage of this murder case in our next hour. Claudia King, thank you so much for making the time for us this morning. Rick Grundy, you are coming with us. We appreciate your time, and we're going to dig into the jury instructions. That second-degree murder charge, does it fit? That's next. Good Tuesday morning to you. We're so grateful for your company here on Court TV Live. I'm Julie Grant, and together we're on a verdict watch this morning. We're in Dedham, Massachusetts, awaiting the verdict in the retrial of defendant Karen Reed. This woman is accused of killing her boyfriend, Boston police officer John O'Keefe. The allegation is that she was drunk and enraged and hit him with her SUV, knocking him over and causing him to hit his head and die in the snow. That is the allegation. Her defense team says the collision never happened. Live look at the verdict clock, 10 hours, 5 minutes and counting. And while we're waiting to hear anything from the jury, we're playing the best testimony from the trial. Let's go in and listen to some of what John O'Keefe's dear friend, Jennifer McCabe, had to say when she was called to the stand as a witness in this trial.
I want you to take us back to that morning, about 20 or 30 yards before you get to Fairview.
Mm-hmm.
You're in the car with Miss Roberts and the defendant?
Yes.
What's happening in the car?
Karen's is screaming, and at that point she had asked if John could be cheating on her and if John could be with Bella's mom.
And then what happens?
Didn't know what the hell she was talking about. I was like, what are you talking about? Why would he be with Bella's mom? And then Carrie said, well, do you think he could have walked to, there was another woman years before that John had dated who lived on the next street over to her house.
Okay. And as you approach that area before you get to the flagpole, does anything remarkable happen?
No.
Okay. What happens next?
As we're driving down the street, I just say to Carrie, because she doesn't know where my sister lives, oh, her house is just at the bottom of the street.
Visibility still difficult?
Yes, awful.
What happens next?
We continue, driving, and we're driving slowly past, the line of, I guess, bushes and the flagpole area. And all of a sudden, Karen's screaming from the back, there he is, or something to the effect of, there he is, let me out.
Did you know what she was talking about?
I had no idea.
When she was yelling that, did you look out the window?
Yeah, we had our eyes peeled out the window.
Did you see anything?
Nothing but snow.
How long was she yelling about whatever it is she was saying?
Carrie, she screamed, stop, so Carrie stopped pretty quickly. There he is, there he is. She could have kicked the door, like, let me out of here.
And when she was kicking the door, what were you doing?
I was just like, what the heck, what is going on?
What happens next?
She gets out. Carrie looks at me and said something, like she's bat crazy.
Then what happens?
Then Carrie got out. Then I got out of the car, walked around the back of the car, and was walking over to where I could see the girls were.
Now at that point, you were in Carrie Roberts' car.
Yes.
It had his headlights on.
Yes.
Was it facing up the street of Fairview?
Well, we had come down the hill, so yes, up the street.
There was no other lighting in that area?
I do not believe so.
No fire engines or ambulances at that point?
No.
No police cars?
No.
Any street lights?
It was dark.
When you got out of the car, did you look towards the area of the flagpole?
Yes.
Could you see anything at that point?
No.
How close did you get to the area of the flagpole before you could first actually see something?
Well, I saw the shadowy figures of Carrie and Karen, and it wasn't until I got very close over to them that I saw Carrie removing the snow from John's face.
Is that the first moment you realized that was John O'Keefe on the ground?
Yes, it was.
When you see Carrie removing the snow from John's face, what do you do?
I was frozen. I was shocked. I couldn't believe that was him just lying there.
Tell us what you're seeing.
What do I see? I see Carrie just wiping the snow off. Karen had straddled him and had lifted her shirt in his shirt and was laying on him, and Kerry was screaming at her to get off of him. And I was literally just stunned. I mean, there he was.
What did John look like when you saw him?
I couldn't see much but his face, because the rest was snow, and Karen was moving over him, but he just looked like just him, but just like frozen.
What did you do?
At first, I just stood there for a minute because I couldn't believe it was him. And then Kerry Roberts and I made eye contact. And I knew, I was like, all right, I'm going to call 911. But I think I knew in that moment that John, was dead.
Did you call 911?
Yeah, I started to call 911, and Kerry and Karen were just screaming. And so I walked back towards Kerry's car, and then Kerry was also yelling at me to go to the back of the car to look for blankets and towels. So as I was calling 911, I was at the back of the car looking for the towels and the blankets to bring over to Kerry. And while I was doing that, I believe 911 answered.
Did you speak to 911?
I did, yes.
Did you get the towels and blankets that Kerry had requested?
I did, yes.
After your phone call with 911 and you had the towels and blankets, tell us what happened.
Over to Kerry, Karen, and John. And at that point, Kerry asked if I would take over compressions. So she got up, and I started doing compressions, and Karen was doing mouth-to-mouth.
When you started doing compressions, were you touching John over his clothes or touching his skin?
I don't remember.
Did you, at that point, get a chance to touch John's body and see how it felt temperature-wise?
I just remember when I was doing the compressions, I don't really know how to explain it. It just felt very funny.
I'm sorry, very what?
It just wasn't like normal. What? I don't. I can't think of how to describe the way it felt when I was trying to press down, but it was like resistance.
How long did you try to give compressions and give aid to John for?
Until the police came.
We have some breaking news right now in the coroner affair murder trial of defendant Megan Jackson. This case is happening in the state of South Carolina, and the state has rested its case. We also know that the defense is choosing not to present any evidence, and that cannot be held against the defendant, who is accused of killing her boyfriend, Gregory Rice, who was also the father of her children. Let's take a look at the background on this trial.
On October 5th, 2020, 46-year-old Gregory Rice was reported missing by his ex, Megan Jackson, the mother of 4 of his children. For a month, police searched for Rice until a fisherman found his body wrapped in a tarp and weighed down in a South Carolina river. Investigators quickly turned their attention to 2 people, Megan Jackson and Christopher Dontel, a married Horry County deputy coroner with whom she was having an affair. In a bond hearing covered by WBTW, the state revealed the romance that prosecutors say turned deadly.
Ms. Jackson, Wells, Ms. Dontel did admit to having an affair during this period of time, which lays the background for the allegations in this case.
Court documents show Jackson worked as a body transporter, delivering remains to funeral homes. It was during this work that the affair started. According to police, Rice was killed at the Myrtle Beach funeral home. Dontel was caught on camera buying items found with Rice's body.
Inside the shopping cart are 2 cement blocks, zip ties, a silver and brain tarp that the body was covered in.
Both Jackson and Dontel were charged with murder, conspiracy, and kidnapping. Dontel was slated to go to trial first, but moments before opening statements were to begin, he took a deal.
Are you pleading guilty to these charges freely and voluntarily? Yes.
The state dropped the murder charge, and Dontel pleaded guilty to criminal conspiracy to commit murder and accessory after the fact.
He has always wanted to plead to that. He was not charged with that until very recently. It's always been very clear as to what he regrettably did.
Dontel is expected to testify against his former lover, Megan Jackson. Jackson, however, maintains her innocence.
That was Matt Johnson there reporting for us. Now let's take a listen to the defendant's exchange with the judge that happened just moments ago in the courtroom.
If I can get you to stand and raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Your name is Megan Marie Jackson?
Yes.
All right, Ms. Jackson, at this time, I'm going to explain to you certain rights that you have. If you do not understand anything I say, please let me know. And if you want me to explain anything in more detail, please let me know. Do you understand that?
Yes.
All right. We've now reached the stage of the trial where you may present your defense. You have the right to claim the protections given to you by the Fifth Amendment to the Constitution of the United States. This amendment states in part that no person shall be compelled in any criminal case to be a witness against himself. This means that you cannot be required to testify in this case. You have the right to testify on your behalf. However, no one can make you testify. This is a personal right, and no one can waive this right except for you. If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be questioned and examined and cross-examined on any relevant issue in this case. In addition, if you have any convictions involving dishonesty or false statement or for crimes punishable by imprisonment for more than 1 year, and this court determines that the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor will be able to introduce your record to attack your credibility. Now, are there any prior?
No, Your Honor.
If you decide to testify, this decision on your part must be freely, voluntarily, and intelligently made with the knowledge of the protections given to you by the Fifth Amendment to the United States Constitution and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It's left entirely up to you whether or not you testify. You may talk with your attorney, your friends and family, or anyone else, but the final decision will be left entirely up to you. Now, do you understand what I've explained to you?
I do.
Do you have any questions about what I've explained to you?
No, sir.
Have you discussed with your attorneys whether or not you should testify in this case?
Yes, sir.
All right. Do you feel like you need to talk to your attorneys anymore about this issue?
No, Your Honor.
All right. Is there anybody you feel like you should talk to about this issue before making a decision?
No, sir.
Have you made a decision as to whether or not you wish to testify in this case?
Yes, sir.
And do you wish to testify in this case?
No, Your Honor.
All right. And is this your decision?
Yes, sir.
All right. Anything further the defense wants on the record regarding the defendant's right to testify?
No, sir, Your Honor. We talked to our client thoroughly about her right to testify, as have you, and this is her decision, and we stand by her.
All right. Anything further the state wants on the record regarding the defendant's right to testify?
No, Your Honor.
All right. Will the defense be putting up any other witnesses or any other defense in this case?
No, sir. No, sir.
All right. So I guess all we have now is closing arguments, charges, and deliberations.
Yes, Your Honor.
All right. Let's take about, I've got some of the charges done. It's probably going to take me about another 30 minutes.
We expect the jury instructions to be given to the men and women of the jury sometime this afternoon. And then We'll be on a verdict watch in that case as well. If you'd like to see the closing arguments online for you. So if you want, you can go to courttv.com right now. We're going to be streaming those arguments in South Carolina in the coroner affair murder trial. In the trial in Massachusetts over the murder of Boston police officer John O'Keefe, we're showing you a live look at the courthouse right now. The jury deliberating for 10 hours, 20 minutes and counting. When we come back, more of the best moments from John O'Keefe's dear friend and case witness, Jennifer McCabe.
Michael didn't do nothing to Sarah. He's still innocent.
Michael Colucci on trial again for the murder of his wife.
This is just not an easy case.
What makes you say she tried to kill herself?
She put herself around a hose or something. I don't know.
Colucci's first trial was full of drama and ended with a deadlocked jury.
We may never know exactly what happened that night that ended in Sarah's death.
The Garden Hose Murder Trial. Live coverage today, only on Court TV.
How's it going? Not going to be any comments right now, guys. Nothing? Nope.
How do you get through the waiting?
No comment means no comment.
There is a gag order in place for the attorneys in the Karen Read trial. We're looking at the verdict clock. 10 hours, 25 minutes and counting. The jury is in that deliberation room. We haven't heard any comments or questions, anything coming from that room. If we hear anything, we will bring it to you live. Before we go back and continue our coverage there in Massachusetts, I want to show you the other cases that we're tracking right now around the country. So in New York City, we've got Diddy's federal sex trafficking and racketeering trial underway again this morning. We have our team there on the ground. We'll be providing updates. The government seems like they're winding down their witnesses, so they could be resting their case soon. In South Carolina, we've got the closing arguments expected any minute now in the Coroner Fair murder trial. Defendant Megan Jackson not testifying, and the jury cannot hold it against her. And then while that trial is coming to a close in South Carolina, another one is just beginning. The garden hose murder retrial for defendant Michael Colucci. This guy is accused of murdering his wife, Sarah. But his defense is that she strangled herself with a garden hose outside of their jewelry store. You may remember this trial. We brought it to you some years ago here on Court TV. Now, let's head back to Massachusetts as we continue on the verdict watch in Karen Read's case. This is over the murder of her boyfriend, Boston police officer John O'Keefe. And some of John O'Keefe's dear friends were dragged into this case and became witnesses because of Karen Read calling them in the middle of the night. Last hour, we showed you testimony from Carrie Roberts. In this hour, we're focusing on testimony from John's dear friend, Jennifer McCabe. Karen Read called her that morning, woke her up the night of the blizzard, the night that John was killed, and told Jen that she didn't know where John was, that he never came home, and that she last saw him at the Waterfall Bar. Jennifer McCabe told her that that wasn't true. She remembered seeing Karen Read's SUV outside of 34 Fairview Road, and Karen Read hung up the phone.
And then at one point, we saw them moving John towards the ambulance. And at that point, Miss Read started yelling to Miss Roberts, "Go check on him. Are they working on him? Is he dead? Is he dead?" And at that point, myself and Miss Read got out of the car, and she started yelling and pulling on me to Google hypothermia and Google how long it takes for somebody, you know, to die in the cold.
When the defendant first asked you to Google an inquiry about hypothermia, were you still inside the police cruiser or were you outside?
Outside.
What was the weather? I know it's an obvious question, but how cold was it?
It was very cold, windy, the snow was blowing. As I stated, I have multiple sclerosis, so when I am out in either extremely hot or cold temperatures, I lose the feeling and sensation in my fingers, which obviously made the Googling very hard for me to do because of my, you know, motor skills.
So when you were outside of the car with the defendant and she had asked you to do a search regarding hypothermia, did you try to do that?
Yes, I did.
Do you know the exact time from your memory? Not from reading or learning, but from your memory. Do you remember the exact time you did that?
No.
Was it after the police came that morning?
Yes.
Had you ever attempted to search about hypothermia any time before that moment, that morning?
No.
Or that day?
No.
That week?
No.
Was this the first time that morning after the defendant asked you to search that you searched that phrase?
Yes, it was.
And did you complete your search and get a result?
So I don't know what came up because I think as I entered it, I think I misspelled things. And so then I think I tried a second search. And again, I don't think I even paid attention to what came up because we were already on to the next thing. Karen was already moving and screaming about, you know, the next thing to Kerry. Are they working on him? Is he dead?
Did the defendant move somewhere from the point when she first asked you to try to Google about hypothermia to something else?
She was next to me, and then I think she took off. Like, she kept kind of running off.
And what did you do?
I believe as they were putting, I think I stood there, I believe as they were putting John into the ambulance, I went back kind of to the original spot where we had been talking to the police. And at that point, a new officer might have come because I remember talking to multiple officers there.
At some point, did you go back towards the area of Miss Roberts' car?
Yes, that's where I'm referring to, sorry.
At some point, were you with the defendant when she spoke to an officer and a first responder?
Yes.
Do you remember if the first responder was a man or a woman?
I remember there was a woman right next to us, yes.
Do you remember if that was before or after the defendant asked you to search about hypothermia?
I'd be guessing if I then don't.
Don't guess.
Mm-hmm.
When the defendant was speaking to the first responder, the woman, were you near?
Yes.
Did you hear or do you remember the defendant saying anything to the first responder?
Yes.
What did she say?
She told the first responder, I hit him, I hit him, I hit him.
When she told the first responder, I hit him, how did you react?
I was like startled, kind of like, what are you saying? What are you talking about?
Did you say anything to the defendant?
I think after the second or third time she was saying it, I was like, Karen, like, what are you saying?
Why were you trying to interrupt her?
Because I thought she was just talking crazy, and I'm saying, why is she saying she hit him?
Were you trying to look out for her?
Yeah.
Sustained. I'll strike it. You can ask it differently.
What was your motivation for trying to interrupt the defendant making the statements to the first responder?
Karen was hysterical, irrational, kind of.
I'll move on. After you made the search at the defendant's request for an inquiry regarding hypothermia, did you have a chance to speak to the officers further?
Yes.
Did they ask you to do anything or go anywhere?
Yes. The Officer Lank asked me to go into my sister's house and to wake them up.
And your sister's name again?
My sister, Nicole.
And that is the house you were in the night before?
Yes.
And after you spoke to the officer, they requested you go in to speak to your sister, did you?
Yes.
Was there any directive on what you should speak to your sister about?
No.
Jen McCabe becoming a witness in this case because of the defendant reaching out to her that morning of John O'Keefe's death, that morning, January 29th of 2022. Now, let's remember, defendant Karen Reed was not friends with Jennifer McCabe or with Carrie Roberts. John O'Keefe was the common thread. And it was really for John and looking out for John that these women went and joined the defendant in that so-called search for him that morning when only Karen Reed could see him on the side of the road underneath that big mountain of snow. Let's talk about this case and let's talk about the charges. Who better to talk about the charges of the case than a former homicide prosecutor, and not just any homicide prosecutor, the man who formerly headed up the office, the homicide unit in Norfolk County, Rick Grundy. He's an attorney in the private sector now. Rick, good morning. Thank you for being so generous with your time this morning. Such an important day as we look at what's at stake for everyone on both sides of this case. For Karen Reed, it is her liberty that's at stake, as you know. For the O'Keefe family, it is justice in the death of their loved one. So much at stake. And the highest charge here is murder in the second degree. And we've pulled the law, and we have you to thank, Rick, for directing us to this, as you are licensed to practice there in the Commonwealth. The exact section of the law that the Commonwealth needs to prove in order to substantiate that second-degree murder charge. So if we could show that on the screen. Rick, if you would kind of walk us through whether you think the facts fit here. So it's actually not these two first subsections. It's subsection C. The defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. Rick, is that charge appropriate here?
Well, I think it is if the Commonwealth can prove the case that they've put forth as their theory of it. And just to be clear, it's a strange statute, and in Massachusetts, it comes into play most often when it's a lesser included of first degree and kind of a bartered decision amongst the juries in certain cases. Because it's a hybrid. We saw A there was if he intended, the defendant intended to kill. Well, that's a first degree. And now we drop down to C. There's not a lot of difference here between either a motor vehicle homicide while under the influence of alcohol or even a manslaughter charge, because we're at this reckless negligence. So in this particular case, if Ms. Reed put her car in reverse and at a high rate of speed backed it into towards even Mr. O'Keefe with the intention, with no intention other than to scare him, but certainly not to kill him, that could fit into that category, because a reasonable person would have realized in doing so there was a substantial chance that that person could sustain injuries that would cause their death. And that's the Commonwealth's theory.
Yes, this explanation is really important, Rick. Let's key in some more. So, to be clear, under the law here with second degree, the Commonwealth doesn't have to prove that there was any intent to kill John O'Keefe, right?
Under subsection C, there is no intent whatsoever.
And then how about even any intent to hit John O'Keefe? Do they need to prove that?
They do not. If the actions taken had a reasonable likely outcome that that person would sustain an injury that would result in the person's death, then they have fulfilled their obligations.
And so on these facts, the Commonwealth's position is that it is enough that Karen Reed drove forward and then made a decision to drive backwards, knowing that she had just dropped off her boyfriend at the house and he was behind her SUV.
Right, driving backwards at a high rate of speed where there are pedestrians, just in that kind of generic situation would establish this.
This is really interesting, Rick. So I think what can be tough, and this is a comment I hear a lot, and perhaps you do too, I will hear folks who maybe haven't followed the case closely or just turn on the TV and you see, and I've complimented Karen Reed before, and I'll do it again, always dressed beautifully, showing respect for the courtroom, the process, you know, coming into courtroom dressed like one of the lawyers, and optics matter. And I've had folks say to me, well, this is a murder case. She doesn't look like a murderer. I've had many people say that to me. And my response is usually, well, what do you think a murderer looks like? Do you think she looks like a DUI defendant? And I explain, if you go into a courthouse, any courthouse, pick one across the country, and you look at someone charged with a DUI, I bet you're going to find people that look a lot like Karen Reed. I have seen them. You have business people. You have people with jobs. She was working as a professor, as I understand it, and was working in the finance sector. I don't know if she's still employed at this point. I have no idea. But you see people looking like that. And if you look at this case that way, starting with the allegations that it's a DUI case, does it seem fitting? Rick, I'm curious, do you hear those comments too, that people will make a snap judgment just on how someone looks?
Absolutely, absolutely, and I have throughout my career. And one particular matter pops into my head. I had a murder trial. The defendant was a actually nationally known physician regarding child asthma. He was a Harvard professor, and he simply wasn't the person that people would think would murder somebody. And I did in my closing, I said, I want you to put in your mind how that person who would commit a murder looks like. and then apply these facts to that person. And if that person in your mind that looks like a murderer is guilty, so is this person, because the facts are the same. Those are natural judgments that we make based on, the same common sense that, in my opinion, leads juries to get to the right verdict. They start out with that, and that's part of the challenge, is to get them beyond that.
Boy, that's really brilliant, Rick. I love what you do there. If they have in their mind some kind of monster, somebody that looks like Charles Manson or something, then you say, okay, just plop him into these facts and make the application and then see what you've got. Don't let yourself just make a snap judgment on someone's looks alone. Rick Grundy, always great, insightful analysis from you. Stand by kindly if you would, please. We're going to hit a break. When we come back, more case analysis. We continue on that verdict watch. We're getting close to the 11-hour mark. And when we come back, we'll watch the cross-examination of case witness Jennifer McCabe.
The hardest part is him being forgotten about. And, you know, when we're supporting one another through the trials, as family members and friends, we get called murderers, we get booed on, just by supporting one another and wanting justice for Johnny. But he's not being remembered on who he was, and he's just being forgotten about through this whole thing. And I think that's the biggest tragedy out of this, everything.
That was John O'Keefe's cousin, Renee Rizzitano, and John O'Keefe's dear friend, Jackie Dugal, who came on the program with me yesterday morning, sharing their thoughts about John, what they miss about him, and how they are hoping and praying for justice with this case. We continue on the verdict watch. We're approaching the 11-hour mark. A live look at the courtroom. That ceiling fan that has become famous. No movement in the courtroom, no word from the jury deliberation room. We will keep you posted. Right now, let's look back at a little bit of the cross-examination of John's close friend, Jennifer McCabe.
There was a Google search on your phone at 2:27 a.m., correct?
Which Google search are you referring to?
It doesn't matter, Ms. McCabe.
Well, I know I did Ozone and I did Hockomock Sports.
And I didn't ask you that.
And those were the only two things that I Googled.
I didn't ask you what you Googled. I haven't gotten there yet. We're going to get there. I've asked you, was there a Google search at 2:27 a.m. on your phone?
If you want to show me a report.
Sure.
Okay.
You don't remember, as you sit here, you don't remember that.
I don't.
You have no record, you have nothing in your mind about a Google search at 2:27 a.m. That's what you're testifying to in front of this jury right now.
Are you asking me if I made a Google search at 2:27? Yes. I don't know what time I was searching for Hockomock Sports and Ozone. I have no idea what time that was.
Are you denying that you made a Google search at 2:27 a.m.?
If you could show me this Google search, I'd appreciate it.
You indicated you wanted to see a record, Ms. McCabe. Did you see a record that indicated a Google search? Not what the content of the Google search is, but there was a Google search.
I just saw a Celebrate record, yes.
And did you see the time of the Google search?
On that record, yes.
Is it 2:27 a.m., correct?
Yes.
Ultimately, you will agree that there was a Google search done, and now I'm going to ask about the content of Hoslong to Die in Cold, correct?
That was done in the morning at the request of Ms. Reed.
Ms. McCabe, I didn't ask you that. I asked you a yes or no question. Did you understand my question?
Could you repeat it, please?
Sure, I'd be happy to.
Thank you.
Did that record indicate that there was a search at some point done, at some point, for Hoslong to Die in Cold?
I object to her reading the record.
So was there a search on that at some point?
On that paper, was there a search that said that? Is that the question?
Let's start with that.
Yes. Yeah, there was.
Okay. Now let me ask you a different question. You Google searched the phrase Hoslong to Die in Cold. Yes or no?
Yes.
On January 29th, correct?
Yes.
So you agree that you were on Google, correct?
Yes.
You agree that there was a search done at 2:27 a.m., correct?
I don't recall doing a search at 2:27. The paper says it. I don't.
Okay. And you also agree that at some point that morning, you plugged into that phone Hoslong to Die in Cold. Is that right?
Yes, after we found John O'Keefe.
Now, you claim that that was at 6:23 and at 6:24.
Now, we know that the defense backed off of their contention that this search happened at 2:27 a.m. For years, they said it and said it loudly and argued that it proved some sort of conspiracy, and then they conceded that, very quietly conceded that Jennifer McCabe was telling the truth all along, that the search happened at 6:23 in the morning when Karen Reed directed her to make it. But we're still going to watch another portion of the cross where Ellen Jackson is grilling her, accusing her of making that search at 2:27 a.m. We'll be right back.
We're getting you ready for the biggest trials across the country before court is in session. Plus, deeper dives into true crime stories with our daily spotlight.
Opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
It's the biggest story that we're covering. He is the boogeyman.
So many eyes have been on Donna Adelson from the beginning.
A social media sensation, now a suspected killer.
Reed, how are you getting through the deliberations, this waiting game?
Praying.
Are you playing checkers or anything like that?
No, I don't play checkers. Praying.
Praying.
Yeah.
And what about Karen? Are you waiting with her?
Oh, sure.
Yeah.
I'm going to be with her right now.
That was defendant Karen Reed's dad strongly supporting his daughter. We've seen him and Karen Reed's mother every single hearing that's happened, pre-trial through every single day of both trials, strongly supporting their daughter whose liberty is at stake. Right now, Karen Reed's liberty is in the hands of the men and the women on this jury. 7 women, to be precise, 5 men, a jury of 12, deliberating the case for almost 11 hours so far. Let's go back into some testimony now. Jennifer McCabe being cross-examined. Here we go.
There's also a connection to Canton Police Department through Kevin Albert. Is that right?
Object.
Can you answer that? Is there a connection? Do you have a connection with the Canton Police Department through Kevin Albert?
Not with the police department, but Kevin Albert is Brian Albert's brother.
Right. And Kevin works for whom?
The Canton Police.
Thank you. So you've been interviewed many times by different law enforcement agencies, be they Massachusetts State Police, Canton Police, or otherwise, correct?
Yes.
Okay. Those interviews have not just been over the period of weeks, it's been over the period of weeks and months and even years since this occurred, correct?
Yes.
You were contacted by another law enforcement agency that was not Massachusetts State Police and not Canton Police Department at one point in April of 2023. Do you remember that?
Yes.
I want to talk for a second about that series of interview, or that interview. You were contacted at your residence by these members of this law enforcement agency, correct?
Yes.
All right. Later that same day, you did sit down with those same law enforcement officers for a formal interview.
On that
same day that you were contacted by them, they also went into your home and actually interviewed you, correct?
Yes, it was brief.
All right. Those law enforcement officers identified themselves as being associated with an agency that is not Massachusetts State Police. You understood that?
Yes.
And you understood that they were not involved with Canton Police Department either, correct?
Correct.
Completely separate agency, is that right?
Yes.
During the course of that interview, those officers informed you very specifically, Ms. McCabe, that it is a crime to lie to them, even during an interview, correct?
Yes.
Those law enforcement officers informed you that they were investigating certain circumstances attendant to John O'Keefe's death, correct?
They were very vague on what they were.
Understood.
I don't know what they were investigating.
But you did understand that it was having something to do with your involvement at 34 Fairview on January 28th, 29th, 2022.
Objection.
As a witness or otherwise?
Objection.
Sustained as to certain terminology, Mr. Jack.
Sure. Let me see if I can rephrase that, Ms. McCabe. You were aware of the subject matter of their interview, right? They weren't interviewing about a car you bought last year, correct?
Correct.
They were interviewing.
We've got some breaking news. We understand that the jury has a question. We're going to let the clock continue as we wait for the judge to take the bench and provide some answers. We're approaching the 11-hour mark of the deliberations. We don't know what the question is. We just got word from our team on the ground that there is something that this jury has a question about. While we wait to hear what it is, I want to bring in attorney Rick Grundy. He's in the private sector now in Massachusetts. He's a heavy hitter there. He formerly was a prosecutor and headed up the homicide unit in Norfolk County. Rick, while we don't know what the question is, and if we get it before we have to take a commercial break, I'd love you to weigh in on it. But something else that we've wondered about here, if, and we don't know if Karen Reed will be convicted. She could be acquitted, could be a hung jury. We have no idea, obviously. Let's just say for the sake of our analysis, if she is it likely that the judge would revoke her bond immediately and remand her into the custody of the local sheriff's department?
Yes, it is, for the reason being that the charges she faces have minimum mandatories. So regardless of what the sentence would be, she would be serving time. And under those circumstances, the court would, in most circumstances, revoke that bail, take the person into custody. In this situation, particularly with respect to a murder, because people obviously have the stronger impetus to flee. But in this situation, I don't think there would be a concern on behalf of the court with respect to those factors. But still, in light of the fact that the person, based on that verdict, unless there is a strong situation where they feel an immediate appeal will yield some results, they're likely to not take any chances, revoke the bail, put the person into custody at that point.
Rick, appreciate it. And so quickly, because we have about 10 seconds left, would you expect her defense team to ask for a report date if she were to be convicted?
I'm sorry, I lost that. A report of what?
A report date if she were to be convicted. Would you expect them to ask for a report date?
Yes.
Yes. Rick Grundy,
Yes,
you're the best.
absolutely.
Thank you for answering all of our questions. We are waiting to hear what the question is from this jury. We'll have a live report for you coming up right after the break.
Welcome back to Court TV Live. I'm Ted Rowland's going to be with you on this Tuesday. We have a question. The first question since this jury deliberating the fate of Karen Read has had. Let's go into the courtroom. Judge Cannone is on the bench.
Please be seated. Court is in session.
Excuse me. I was just informed some of the accused. Just
So, counsel, why don't you come on up?
Okay, Judge Cannone not allowing us in on possibly the question yet. They are at sidebar, and we will wait. We'll keep up. We'll show you the sidebar video, but let's bring in Vinny Politan outside the courthouse. Actually, hold that thought, Vinny. Stay where you are. We're going back in, and we'll see. We're going back into the courtroom. Let's go in.
Bob, I can't do this. I can't do this.
Okay, if you're just joining us, Judge Cannone came on the bench. They had a sidebar. They broke up the sidebar, and now it's each camp conferring, but nothing on the record in, well, it was obviously on the record with the court reporter, but we don't know the question yet. I assume we're waiting for the jury to come in, but we don't have a feel for what's going on. You can see Alan Jackson is writing something down, and Robert Alessi is, as characteristic, up and chatting with Yannetti, along with Karen Read, who's been she's been front and center in her defense throughout this entire saga, and we're seeing that now. They seem to be drafting maybe with their proposed answer to the question. On the other side, Brennan doing the same, writing out what they believe should likely be the answer. Cannone, you could see getting up off of her chair, getting ready to receive these proposed answers from each counsel. Brennan is still working on his. Jackson just gave the, well, now everybody's getting up. Again, no audio from the courtroom. Very interesting. Matt Mangione is with us. He's a former prosecutor and defense attorney in Pittsburgh, Pennsylvania. Matt, and I'll cut you off as soon as we get audio. What do you think's going on here?
Well, I think you're right, Ted. I think they're going through the question or the answer that each side would propose to that question. We don't know what the question is. Obviously, it's important to the jury. It'll give us some insight into what the jury is doing during this deliberation. But both sides are going to want to make sure that this answer that's proposed, is something that supports exactly what the prosecution or defense is trying to prove in this case.
You can see the bailiffs in the white shirts. It looks like the security has definitely increased once we get into verdict watch. In any case, it does increase, but you can see several security members, and now you're seeing the family members being escorted into their positions in the courtroom. The O'Keefe family in their normal spots, including John O'Keefe's mother, who has been a fixture, Peggy O'Keefe, at this trial and the first trial. The family has gone through hell and back and are here for justice. On the other side, the Reed family, of course, have supported their daughter, Karen, throughout. Oh, we got some audio.
To you now, so please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay, so it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
All right.
Okay, there you have it. The jury had not just one question, but 3 questions after 11 hours plus of deliberation. Each side getting 15 minutes to craft their proposed answers for them. Well, what's the time for the OUI charge? 12:45 or 5 a.m.? Question number 1. Video evidence. How do we consider it? Are the videos evidence? And then that last one. Does convicting guilty on a subcharge affect the overall charge, basically? Again, it's the verdict slip. This was a huge problem the first time around. That first Karen Reed jury found her not guilty of the top 2 charges, but couldn't figure out the verdict form. And here we are again. Let's bring in Vinny Politan, lead anchor. He's been through many of these cases and seen many different versions of jury questions. Your initial thoughts, Vinny, especially on that third question.
No, I think they're related. I think these questions are related. They're talking about OUI. They're talking about OUI, Ted. They're not talking about murder. They're not talking about manslaughter. They're not talking about involuntary manslaughter. They're talking about what is the impact of finding her guilty of OUI. And I think the confusion probably is on that second page of the verdict slip where there's just one not guilty. And I think they're a little confused as to how that relates to all the charges until you get to number 5. But if I am on the defense team right now, probably a little optimistic at this point. If I'm a prosecutor, which I was, I'm not feeling good about this question at all. Now, I could be totally off. Sometimes a question is just from one juror. It's not from all 12. There might be confusion from one juror. But though I'm reading these together, Ted, they are connected. What's the common denominator here? OUI. Was she driving under the influence at 5:07 or was she driving at 12:45? What did Alan Jackson say in his closing argument? We don't know what she did between 12:45 and 5:07. We don't know when the alcohol was consumed. We know when the blood was drawn. We know when the test was done. It seems to me they want to know. If it's about 12:45, we might have reasonable doubt. If it's about 5:07, okay, maybe she drank afterwards.
How does the video question
I have no other way to
in?
read this, Ted.
Yeah.
Do you have another way to read this, Ted?
I think you're spot on. The confusion over the verdict form is something the defense was concerned about before they went back to deliberate, and Judge Cannone was insistent on keeping what they had drafted. What about question 2? Is the video, are the videos evidence, and how do we consider them? If your gut is correct that it's all about alcohol, she did talk about consuming drinks in the video evidence.
And that was one of the, and that was one of the things we talked about early on, right? There was a whole series of videos that they played early on in the case where it's her talking about how much did she drink. That would be an admission, a confession to drinking. So again, I think all these things are potentially connected. Now, obviously, the prosecutor says there's a lot more to those clips that he played for this jury, but the other 2 questions are not connected to that. If you want to look for the common denominator in all 3 questions, it's drinking and driving. It's not murder.
Yeah,
I don't know how else to read this. Now, again, everyone needs to know, you know, I know, we've covered these before. Sometimes questions come from 1 or 2 jurors that might be in the minority that are asking these questions, and the others want to say, okay, we'll ask the questions, and then you've got to come along with us. But if this is the jury speaking as a whole, this is enormously good news. I would be much more optimistic if I was on the defense side, which I never was. But as a prosecutor, I would not feel good about these questions at all. They're talking about OUI. They've gotten all the way down to the bottom charge of count 2, Ted. We're not debating manslaughter, involuntary manslaughter. The first jury, that's where the first jury was. They were debating involuntary manslaughter.
Yeah,
they've gotten below that.
If they have found her guilty of murder, they don't care about the OUI. They would just
it's irrelevant.
Yeah, and they would find her guilty of that just because. So that's a great point.
Let me tell you something else, Ted.
Yeah.
Can I throw something else in for the folks watching at home?
Yeah.
You ask a question like this, once you get the answer, a verdict could follow very, very quickly after the answer. Now, we know there's going to be at least 15 or 20 minutes here. And what we've also seen in the history of court TV, Ted, is sometimes when they take too long to answer the question, the jury sends out another note and says, we have a verdict. So I'm not leaving this spot. Let me show you what's happening right here. This is a moment of anticipation. It's palpable, what folks are feeling out here right now, because everyone, as these questions are being asked and answered in court, everybody's streaming it, so they're hearing it as you're reporting it, Ted. So at this point, I think everyone here is anticipating that something big is going to happen very, very soon. Earlier this morning, the crowd was thinning, much thinner than yesterday. Since this note came out, it's starting to fill up again. As a matter of fact, we have to clear the sidewalk because we got people who need to walk by. But this is a big moment, Ted. This is a huge moment. I'll be here. I'm not leaving. I'm expecting something from this jury, whether it's after the question gets answered or maybe even before, Ted.
Yeah, you're right. These questions do give you the sense that a decision at the end of a verdict is coming, because once they get the answer to this question, assuming they are patient enough to wait, there's not much more to go. If indeed they're that low on the verdict form, that means they've accomplished a lot, and they have worked their way down to that question of drinking and driving, which is a question the defense would love to have answered in any way. They'll take it if they can avoid those top charges. Vinny, stay put. We're just gonna, because we're waiting for both sides to craft their responses, we'll slip in our commercial break now. We'll head back to Vinny and then, of course, back into the courtroom to see what each side comes up with in terms of an answer to these 3 questions from the jury deliberating the fate of Karen Reed.
The WNBA is on iron. Friday, the Wings battle the Sun. Then, the Aces host the Storm. Coverage starts Friday at 7. Find Ion wherever you watch. Ion, it's on.
The brutal murders of 4 University of Idaho students.
Detectives arrested Brian Kohlberger.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
Okay, if you're just joining us, the jury in the case against Karen Read had those 3 questions for the court. And right now, both sides are crafting their proposed answers, which Judge Cannone will consider before answering the questions for the jury. They continue to deliberate 11 hours, 26 minutes, and counting. We are on pins and needles, as are the people outside the courthouse in Dedham, Massachusetts, and that's where we find Court TV lead anchor Vinny Politan, who's joining our coverage. We'll get to Vinny in just a minute. Let's bring in Matthew Mangino, though he is in Pittsburgh, Pennsylvania, former prosecutor, defense attorney. He's been on both sides of this coin. Matthew, your thoughts on the questions? Vinny thinks they're possibly on to the OUI question.
Well, at first blush, Ted, I think Vinny is on point here. It appears that the primary question, the primary charge that they have questions about is the, driving under the influence, the OVI charge. And, if they want to make some determination, as to when this charge would have applied, would it have applied at 12:45 or at 5 a.m., which I think is significant in their evaluation of this case. I mean, they're also asking, about the video clips, and the judge indicated that she would give a humane practice charge, which means that the jurors would be told that if they believe that these statements did not come as a result of being impaired, that they were voluntary and not coerced, that they can consider those statements. But again, it appears that this jury is looking at the lesser offenses, not the murder, not the manslaughter, but maybe only the, operating under the influence charge.
Let's take a look at the verdict form that has been the caught the attention of the defense. They wanted to change it, arguing that they needed to simplify it a bit. But this is what the jury is basically dealing with. And you can see that it starts with this page 1 of murder in the second degree. It's a not guilty or a guilty. That's pretty basic. Now you go into the second page, and it starts to get a little bit more convoluted, if you want, and they may be asking about this one here, because that's what they said in their question as an example. They said, example in charge 2, number 5, and that is guilty of lesser included offense. They wanted to know, well, does that mean if we find her guilty here, will that find her guilty overall on this charge? And the answer there is no. What's your take on the form? Is it confusing, Matthew, especially this one here, because this is the one that the jury has pointed out that they want clarification on?
Well, I think that, in a sense, justifies the defense's concern about the jury instructions, that they were a bit confusing. And Ted, there's always confusion when you're dealing with jury instructions because they're not clear, and they're difficult to understand. And when the judge goes through those instructions, typically, people's eyes gloss over because it's not an easy thing to comprehend when you're being asked to make these decisions and you're checking off these boxes on the verdict slip or the jury instructions. So yeah, I think in a sense this question sort of validates the defense's concern with the instructions.
Yeah, it does. Let's bring in Matt Johnson, who's been covering this since the beginning. He is outside the courthouse as well. Matt, refresh our memory in terms of the defense issue with this jury form. Obviously, after the first case, we had the confusion. Jurors came forward and said, oh, we found her not guilty of the top 2 charges, just didn't understand the process. The defense was concerned about this scenario, were they not, with a motion filed with Judge Cannone?
Yeah, they were concerned about this, Ted, pre-retrial, which is the reason why they wanted that verdict form to be changed heading into deliberations. Then they came back on day 2 of deliberations yesterday. They filed an emergency motion saying that they had hoped to get more not guilties included, or at least the verdict form streamlined for at least count 2. That was denied without any arguments in front of Judge Beverly Cannone, who, of course, presided over the first trial. Her decision was also upheld by the High Court here in the Commonwealth on that issue last year that you were referencing. But let me just show you what's happening right here. So we're going to walk the line. We're going to show you, this is media that are local and from all across the country over here, just the number of cameras. And it goes actually more deep when Karen Reed is out here. And then across the street, we have over at the Registry of Deeds, we have all of those Reed supporters. We're going to continue to walk the line here. So this, again, is all the media waiting for Karen Reed to come out after this short conference and after the judge addresses the jury, the second deliberating jury. Over there, you have a big cluster of supporters over here. You have, of course, state police that have been out here with these barriers, maintaining the peace and the buffer zone. We can actually walk a little bit further over here, Jason. Let's walk the line over here. Again, things like this isn't in place when there is no trial. These barriers here, the barriers here, this is just in place for the deliberations and this jury. You can see that there's a large number of police presence. This is local police that are assisting as the arrival and departure of this defendant. But you can also see the group of supporters that are over here, much less than yesterday, but again, more that we've seen over the past 8 weeks of this trial, Ted.
All right, thank you, Matt. And Matt will be with us as we continue our rolling coverage of the case against Karen Reed. Vinnie Politan also in the crowd outside of the courthouse. That group of people knows the question. What's the mood there, Vinnie, in terms of the reaction from these questions?
Well, the first thing, you've got about half as many people as were here yesterday, which is fascinating to me. That everyone thought the verdict would come in yesterday. But I think there's a level of optimism right now amongst the supporters. The thing about the questions, Ted, that one question about the verdict slip itself could be that they're totally confused. If they're totally confused, our reading of the question about number 5 could be off. If they're completely confused about the second page, which everyone ahead of time agreed was completely confusing. So I think that's where we stand. I think the folks here are cautiously optimistic about this moment. They've been confident since day one. They were disappointed yesterday, fully expecting a verdict and a not guilty verdict. But I think everyone is kind of looking at this the same way we are, which is if they're talking about the lesser included of operating under the influence, have they gone through all the other relevant charges and landed there? Or do they completely not understand the process? And are they trying to do guilty, not guilty on every single charge? But if you're debating operating under the influence and at what time frame, clearly that impacts the lesser includeds above it. So I'm sticking with my original analysis here, unless there's complete confusion in that jury room.
Yeah, and you know, they say an example charge to number 5, it doesn't necessarily mean they're hung up on it, but you would think that they wouldn't have pointed that out unless there was some discussion in that deliberation room about just that. And if indeed it is that, that would be good news for the defense. What about the defense and Commonwealth responses here? And you brought it up earlier. Sometimes you push a jury too long with a response to a question and they'll move on. And we've seen it before. Well, they'll send another note and say, we got a verdict. Oh, Vinny, got to hold off. We got audio in the courtroom. Judge Cannone taking the bench.
Please be seated. Court is in session.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from whoever's, you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
I do not.
Right.
The indictments.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
There's no time for the indictment.
There's no time?
It's just the date.
I don't expect that there's any time to be.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it. Sure. Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them, and then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If
okay.
any. Thank you. Otherwise, it's fine.
We raise the issue of preserving. It's only an line. You're going to hate the whole thing, but I don't think it's going to. You're right. She's going to.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
So sure, you may practice.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
Okay, while Judge Cannone does that, reviews some items, let's slip in a break. We're going to pick it up right where we left off, though. You won't miss a thing. Back right after this. Stay with us. All right, back to the courtroom we go. Judge Cannone done looking at her papers, now addressing the attorneys.
All right, so what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
If the I don't have a a principled objection to it if the court adds the word "if any."
I understand.
Because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, a complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge, 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on?
Under the guilty. So go ahead, I'll hear you further.
Going further, going under number 3, find the defendant guilty of the lesser offense of involuntary manslaughter. We would simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
we fixed it.
Check one of. Okay.
Yes. So we changed of to or.
So my only suggestion to that would be to again add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense, of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop, stop and sign the verdict slip.
Yeah.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay, let's get a break here. Then we'll see the rest of this discussion before the jury's brought back in with these answers. We're watching along with you, along with all of these people outside of the courthouse in Dedham, Massachusetts. We have questions. Don't have a verdict yet, but boy, this jury is obviously working. Stay with us.
for you.
Welcome back to Court TV Live. If you're just joining us, there is movement in the case against Karen Reed. The jury, who's been deliberating now for 12 hours, 11 hours, 56 minutes, has 3 questions for Judge Cannone. Everybody outside that courthouse, everybody at home watching, is wondering, does this mean, are we getting closer to a verdict? So we just heard the defense and their basic suggestion to Judge Cannone how to deal with this 3rd question, which is, does convicting guilty on a subcharge make the overall charge automatically guilty? The answer is no, but then what else should Judge Cannone say? Well, let's hear what Hank Brennan suggests.
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think with the edits, this proposed instruction explains it.
Yes. All right. What
I don't have any issue with if you state, if you decide on a lesser included offense does not include the earlier offense. And I'm not sure of the exact language I can use. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you fill it out with the edits is going to be sufficient for them to follow.
What do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should re-emphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes, thank
you. All right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you all. right.
Be seated. Court is in session.
All right, so we can bring the jurors over. Tori, do you have those? So Tony will take those. All right, so I'll take. Thank you. Tori, how many did you make?
All rise for the court, please. Jurors entering. Court is back in session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set up,
Sure, why don't you come on over? I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, the court, please. Jurors, follow me. Jury is exited the courtroom. Please be seated.
Are you satisfied, Mr. Yannetti?
Yes, Your Honor.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back out in about 5 minutes.
Foot. All right.
You do for ID?
All right.
All right, so we'll see everybody at 1:30.
And
They call it mean you're guilty on the charge. And the remedy there, they went through step by step the jury verdict form. And so they should be good to go there. We do know that at 1:30, all of the parties are to be back in the courtroom. Why? We don't know, but it came after an extended sidebar, and Judge Cannone announced, oh, okay, I'll see you all at 1:30. Now, let's bring in our Matt Johnson. Matt, the lunch breaks for the jury have not been a formal let's all get together and talk to the jury about lunch. So this 1:30 callback, something different is happening today, whether it's how they're dealing with lunch, but this is different, is it not?
It is very different, you know, and we're reading the tea leaves here, but, you know, we're trying to decipher whether or not this 1:30 is for the parties to argue something in the courtroom, which could be a renewed motion. It could be an emergency motion by this defense team after hearing those very pointed questions that you pointed out there. Or is it something more? You know, is the jury going to be brought in and asked another question, or is there something going to be shared with them further? We don't know, but we will be bringing that to you. I can tell you this much, that just a few minutes ago, before you came to me, there was a delivery man that appeared to be from a local restaurant, and he had very large to-go bags, almost that would stack pizzas in it, and he had 2 of them, and he was running up the courthouse steps. So I'm wondering if that is either for the jurors that are deliberating right now and taking their lunch break, or if that is going to be for the court staff, because we do have additional security brought in to this particular small courthouse for this trial, along with all of the state police that line the streets. You have Dedham sworn officers here that assist with the ins and outs in the buffer zone. They're also on bikes, and, you know, they're the ones that are really helping the O'Keefe family. Early on, they were helping also the witnesses when they would walk into the courthouse to make sure that there was no interaction either with the witnesses or interaction with the O'Keefe family that has asked for privacy during this time. And that's the reason why you don't see media asking them questions, and we've already done that. And they've asked for their privacy during this very difficult time for their family as we wait for this jury to decide the case.
Matt, I don't want this to get lost and everything because we've had so much breaking news, but this amended verdict form, if you could recap our viewers on how this jury, they're getting a different form in the middle of deliberations. That's pretty unusual.
Yeah, it is very unusual, especially from Judge Beverly Cannone, that wanted no alterations to the verdict form in trial number 1, and we saw how that turned out. But ultimately, charges were not dropped as what the defense had asked for in higher courts. And then you had this defense team that was asking for an amended verdict form before going into deliberations, before closing arguments. That was denied. And then the emergency motion yesterday on day 2 of this verdict watch, which was also denied. Without any arguments in the courtroom. And the judge was saying that, you know, this verdict form follows state law, legislature, and this would be the verdict form upheld in any court in this jurisdiction. But, you know, it did seem as though she was making some changes to it, not in the wording of the law, but how the law was laid out on the form itself. So I think that that's a huge compromise by this judge, and then the fact that she actually read it out loud to this jury and they followed along almost in a law class. I thought that that was very profound also, because we didn't see that in trial number 1. The jury, the defense actually asked for something like that, more explanation for the jury in trial number 1, and they received it for this retrial.
Absolutely, big difference, and they should now understand-ish that confusing jury form. Marie Prayer's watching along with us, a frequent guest, defense attorney. Your thoughts, Marie, I can't wait to hear them, on where we are and what you believe this jury is thinking.
I'm thinking that because they're asking these questions at all regarding driving under the influence, the time frame, and they're asking about the interviews, are they evidence, and they're talking about subcharge, is not a good look for the defense. I may be, you know, alone in this opinion, but I agree, like Karen Reed's dad says. You never know what anyone is thinking. But in my opinion, those inquiries are telling me they're thinking, was she drunk? And that aligns up with manslaughter, which doesn't require a specific intent. I feel if they're asking about her level of sobriety, what was she like that night, then they can be thinking maybe she accidentally ran him over and didn't realize. That's the manslaughter that doesn't require intent. I'd be worried if I was the defense with that line of questioning from the jurors.
Yeah, Marie, do you think a jury in a murder case would come back with just a DUI charge? Because this gives them a lot of options in terms of if she just left the scene and knew that he got hurt, if this was an involuntary manslaughter where it's an accident. But if they just come back with OUI only, that means, especially if they think it was at 5 a.m. versus 12:45 a.m., that means they just think maybe she was driving drunk. That was 3 years ago. Do you think that's a possibility?
I don't think it's a possibility. I think there's a nexus between the drinking and the manslaughter charge, what they're calling the subcharge. If they find that she was driving drunk, I think it's likely they're going to find that in her drunkenness, she accidentally ran him over.
Okay, we don't know. Let's get a break. More coverage of the retrial of Karen Read right after this.
Welcome back to Court TV Live. I'm Julia Janae along with Ted Rollins, and we are following what is happening on the ground in Dedham, Massachusetts. Karen Reed murder retrial, where the jury has had the case for 12 hours and 30 minutes.
Here is a live look outside of the courthouse as we await any word from inside the courtroom. Will this jury at the end of the day find Karen Reed guilty? Something the first jury in the first trial could not do. They never were able to come to a unanimous decision. They may have had a unanimous decision on the top two charges, according to some jurors that came forward. The bottom line is, here we are. It's a full retrial, and we're waiting for a 1:30 appointment, if you will. Judge Cannone says everybody back here at 1:30. She said it after an extended sidebar. So whether they are coming back equipped, ready to argue something, or if it is something else, we just don't know. But we do know that at 1:30 we'll be watching very intently to see what's going on.
Let's go to on the ground. You see our live look there, our live camera of what's going on outside of that courthouse. We have joining us now lead anchor Vinny Politan is with us. Vinny, great to see you. Tell me what the latest is there where you are.
The anticipation level is high. Everyone who is here is expecting a verdict sometime shortly after lunch. Is it at 1:30? Is it at 2:30? I don't know. They don't know. But the crowd size is absolutely growing. Still not as large as it was yesterday when everyone here expected a very fast verdict. I think word is now leaking out amongst her supporters that now is the time to be at the courthouse, because everyone here expecting that verdict to be handed down at some point in the extremely near future. So that's really it. I see, if you take a look over here to the right, a lot of American flags now being flown in the sea of pink. It's a combination of things here. People believe that there's been an injustice, and the American way is to have a trial, have a fair trial, and let the jury make the decision. So, but obviously the folks here believe that the jury is going to utter two words: not guilty. But we shall see. That's the mood here. There is a high anticipation, a slight lull, because they know nothing's going to happen until 1:30. Yeah, we know that things could go either way, and a lot of times we're absolutely floored by jury verdicts after they come in thinking it's going to go one way and it goes another. So we don't know. Vinny, what we want to do real quickly is a couple things. Talk to you about the interview that you did with the juror that came forward, Ronnie. And specifically, we're going to play a clip of your interview with him. You bring up the confusing jury verdict form in Karen Reed 1. And let's listen to that, and then we'll get your take on that first jury and the confusion and difficulty they had.
Did all 12 of you inside that jury room agree that Karen Reed was not guilty of murder? Count 1 in that indictment.
Correct.
Okay, now let's roll up our sleeves a little bit. How did you vote? Was there a raising of the hands? Was there someone writing down what your vote was? Was it a secret ballot? How do you know, and how was the process that all 12 agreed that she was not guilty of murder? Count 1.
So we all raised our hands in terms of a vote, and we voted on that first count that we all agreed not guilty. Unfortunately, at that time, we did not fill out any of the paperwork there, nor sign it. So we were under the understanding that each charge could not be treated separately. And so we continued to deliberate, despite the fact that we had agreed on 2 of the counts as not guilty.
And the second count was count 3, and the same process where I guess the foreperson is asking for a vote and everyone raised their hands?
And everybody agreed not guilty for those 2 charges. That's correct.
Was there, now you mentioned that you didn't fill out paperwork. Was there any discussion about should we check the box on the verdict slip?
So we didn't check the box on the verdict slip because we were still deliberating on the second charge of involuntary manslaughter, and that continued with deliberation. We did send out notes asking for clarification, but unfortunately we did not ask the question at the time, should we treat each charge individually and separately?
So,
all right, that was a little bit of your interview with that sitting juror in Karen Reed 1, Vinny. Did we get a version of that here now again with this question, third question?
I think we did. I think we did. I think something that our system does, whether it's the lawyers in the system, the judges in the system, even the justices in our system, they don't appreciate the awesome responsibility we give to ordinary citizens to decide these cases. And we presume too much because we do this day in and day out. We cover trials, Ted. Judges preside over trials. Prosecutors prosecute cases. Defense attorneys defend cases. And we don't understand that people coming into the system for the first time don't know the rules. It's incumbent upon us, those who are running the system of justice, to make it as easy and as clear as possible to the members of the public who are given this awesome responsibility. And when we don't do that, the failure is not on the jury for not understanding. The failure falls in only one place, on the system of justice for not explaining it clearly. And it can be explained clearly, but you have to understand. You have to put yourself in the shoes of a jury coming in, never having watched a trial ever. That's the presumption you need to have, that the jury knows absolutely nothing. And I think if we do that collectively as a system of justice, maybe the instructions will be clearer, maybe the verdict forms will be clearer. But here we've had the mistake repeated with this jury. Hopefully the last instruction remedied that. We can just hope that it does, because you don't want confusion leading to an unjust verdict or to yet another hung jury. Clarity is incumbent upon those who are calling ordinary citizens in to decide the case. It's on them and only them.
So true. Clarity. You could have said it any more perfect, Vinny, and you might not can see it, but behind you there's a cluster of Star-Spangled Banners that keep popping up that everyone is holding behind you. And I'm wondering if you're seeing more of those today, and is it because they can't carry posters? I know there's a lot of rules on the buffer zone now.
Right. No one's going to outlaw waving an American flag. You can't do that. Not in this country, and not in the buffer zone. So yeah, there's a lot of that, red, white, and blue happening. I'll take a look at what's happening behind me since you referenced it. There we go. Yeah, it's about the country. And we can't forget that our system of justice is a big part of what the Founding Fathers created for us. Right. The jury system, right? Presumption of innocence. The burden is on the government. If the government wants to take away your liberty, they've got to prove every element of the crime beyond any and all reasonable doubt. But beyond that, what we owe every defendant and what we owe every jury is that everybody understands the rules. And I think that's where we ran into some bumps here in this case. First time around, and unfortunately second time around. But I'm extremely confident by what we're hearing, Julia, from this jury, that they are extremely close. The type of questions that we got are, we're just trying to clear things up here at the end. And I think that's where we are. I think we are seeing the light at the end of the tunnel. I think there will be a decision. What that decision is, right? The 12 will tell us. But again, these folks are anticipating not guilty, and I can tell by the mood. The mood is definitely upbeat, much more so than at the end of the day yesterday. At the end of the day yesterday, there was disappointment. I think you saw it on the defense team. I thought you even saw it on Karen Reed exiting the courthouse yesterday. Much different when they were leaving for lunch today. I thought they had a little jump in their step. Karen Reed, when she turned to the crowd, which I was standing in front of, I could see her give the sign language, the love sign language, but I also saw a smile. Think about it. Your fate is in the hands of the juries, and Karen Reed was able to turn to the folks who are supporting her, folks like this, and smile. So that, I thought, was a huge moment in terms of their mood. and the mood that is now shared by the folks outside the courthouse.
Vinny, what's your take on this 1:30 meeting with Judge Cannone for the parties?
Okay, we know a lot of things happen at sidebar. We're not privy to, right? Because it's at sidebar. I don't know why it's at sidebar, first of all. I always understood sidebar was things you don't want the jury to hear. Well, the jury wasn't in the room and you're still at sidebar. So these are things we don't want the public to hear. Why don't we want the public to hear what's being said in a public trial? I don't understand that. But beyond that, it's, excuse me, very unusual. Extremely unusual to call everyone back. So either they've got a legal issue or something happened in the interim and they know that something may happen with this jury. So I'm on standby for either one.
Now, I do know that there is a question in terms of scheduling on Thursday, and I doubt they would be dealing with this now. It seems way premature. But, you know, you have the jury's been told they have Thursday and Friday off. They were told that before Judge Cannone and all the parties realized they were going to be in deliberations. And there was some mention that that was going to be cleared up. They were going to talk to the jury and deal with that scheduling. But I can't imagine, after those questions, where we are right now, that that's something they're going to do some housekeeping on. But I'm just spitballing.
It may impact how long they go today, because they've been stopping at 4 every day. Maybe they want to give them more time if
But tomorrow's wide open, right? I mean, tomorrow's a full day if they need it.
Yeah.
I'm with Vinny. I don't know what's going on there. I don't think it's a verdict, but I think it's likely that the defense brought something up at sidebar and it needs to be litigated at 1:30.
So much is happening at that sidebar, including the question. We didn't initially even get the question read on the record to us. Vinny, I know that does happen, but what are you seeing in terms of this trial and the way things are kept from the public when that's really one of the big issues, transparency?
Yes. First of all, Massachusetts is great, right? They allow cameras, microphones. There's that level of transparency, which is great. Then you get in the trial and you have other moments. There are times, I understand, when the jury is in the courtroom and there's a legal issue and they could be talking about something that's admissible or inadmissible, legal argument. It gets messy if you do it in front of a jury. We've seen judges do it in front of the jury. You know, and then sometimes if it gets out of control, let's go to sidebar. Here, the rule is sidebar. I get it. That's actually smart. That's a smart call by the judge to make sure the jury doesn't get influenced by anything they shouldn't necessarily hear. But when the jury's not in there and there are things happening on the record, on the public record, but not being discussed openly in court, I'm wondering why. I don't understand the reason why. The jury is deliberating. They won't hear anything. The public has a right to understand and hear what's happening in a public trial because there's public investment. And you think about a case like this where the public is calling into question our system of justice. That's the exact time when you want to turn up the transparency to make sure that nothing is hidden from the jury, that the whole process and procedure is extremely transparent. And we see it done that way in Florida. Florida is the most extreme example of transparency, and the system of justice works very fine. Like, it works as well as it does in any other state. And I think there's a more trust in the system there because of the transparency. So I don't see why you would turn it down at that moment, but there may be reasons. There may be reasons why. So, you know, we'll see at the end of all this. But the important thing, I think, for everyone to understand right now is that the crowd is getting larger. I think word has gone out on social media for folks who are supporting Karen Reed and have been supporting Karen Reed that now is the time, if you want to be here, now is the time to be here to experience a verdict. And I think everyone wants to be here for that moment if they can, those who have supported her through the years. Again, I'm looking for supporters from the other side. I have not come across any. There were a couple of folks I saw who were kind of keeping to themselves near the steps who I believe are on that side, but they're not making it apparent to me. Everyone here is from the Free Karen Reed movement, and they've assembled here. And not just locally, Ted and Julia, not just locally. There are people that have flew in last night to be here. So they're coming in from other states as well.
Fascinating. This is one of those cases. It sure is one that has grabbed the country's attention. Let's get a break here. Vinny, thank you. Stand by. We're waiting this 1:30 reconvenement in Judge Cannone's courtroom. The jury won't be there, but we'll find out what it's all about very soon. Stay with us. You're watching Court TV, your front row seat to justice. Colucci on trial again for the murder of his wife.
This is just not an easy case.
Colucci's first trial ended with a deadlocked jury.
We may never know what happened that night.
The Garden Hose murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, it's the retrial of the century, and we're live from Dedham with all the Verdict Watch updates. We're bringing you the latest insight as the jury deliberates Karen Reed's fate.
Closing Arguments tonight at 8/7 Central, only on Court TV.
What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge?
Welcome back to Court TV Live. You just heard Judge Cannone reading the questions that the jury had in the case against Karen Read. They're back deliberating now, approaching 13 hours of deliberations, along with Julia Janae. I'm Ted Rollins, along with Matt Johnson, Court TV crime and justice correspondent who has been on this case since the very beginning, covered the first trial, and here he is back again. Matt, let's if you would, get us caught up to speed in terms of the mood, the crowd, and as we anticipate this 1:30 gathering. The parties have been ordered back at 1:30 in front of Judge Cannone.
Yeah, you know, during when the question was being read to all the parties and then explained to the jury members, everyone out here was on pins and needles, and it was very quiet. They were holding their phones to their ears. They were watching online. They were trying to get the very latest information. The crowd was swelling in size across the street. You can see right here all of the media assembling as we wait for this 1:30, whatever that is going to be, as we anticipate all the parties being called back into Judge Beverly Cannone's courtroom. Now, across the street, you can see you have all of these dozens of supporters of Karen Read. During the lunch break, they've actually been passing out fans, like hot air fans. That woman in the black that looks like a robe or a graduation gown, she's been handing out fans with Karen Read's face on it. We have seen others passing out American flags. We have other signs over here. So far, just now, the signs are not being enforced like they have been throughout the day and throughout the trial, for that matter, because we are in the buffer zone. This is the Registry of Deeds, giving you a behind-the-scenes look. That's where I stand during the trial, over in the corner. That's where our setup is, and you can see all of these news crews assembled over there. But let's walk this way, because I do want to show you the crowd is lining the street over here and down the block, as they have been throughout the trial. Over here, we have another local news crew, and then also these Dedham police officers. They're assembling. They've been over here, and they keep the crowds away, and they maintain the buffer zone, and they also help with the assistance of the parties when they arrive back to the courthouse, that being the O'Keefes, and that being Karen Read and her attorneys. They are spending the lunch break, and as they have during deliberations over at David Yannetti's office, he has two. He has one in the big city of Boston, and then he has one in this tiny town of Dedham, where this trial has been taking place. Ted, Julia.
Oh, Matt, a lot going on there, a lot of anticipation for this 1:30 moment. We've got another camera, in addition to yours, that is showing the outside of those steps. I'm anticipating that once people do arrive, we'll be able to see them going up the steps, and I know you're right there as well. Can you compare where we are right now to last year? I love the value of having you know both of these trials, and we're there for every day of all of them. But when we were this far into deliberations last year, what did it look like? What did it feel like? What were the questions like?
Yeah, the questions were very different. It was more procedural. It was, you know, what time can we leave? Can we go to lunch? Can we leave early for the day? In one case, you know, it was they were heading into a weekend, and then they came back to deliberate. And then it became, you know, hey, Judge, what do we do in the case that we can't agree on all 12 of our jury members agree on any of these charges? And then after that was the case, a couple of questions. Then that mistrial was declared on July 1st, 2024, almost a year ago. And I also have to say that the mood feels a little bit the same in terms of the weather, believe it or not, because it feels like a storm is coming in. There are dark clouds above head, and we are anticipating possibly rain. And that was the case when a mistrial or a decision was granted after the trial in 2024.
Interesting. Yeah, it's nice to have Matt there, who has experienced all of it and is our resident expert. Well, now he's a resident. I think he might have moved there.
He might have changed his driver's license at this point.
Let's bring in Marie Pereira as we wait again for this 1:30. gathering, if you will. The parties are coming in at 1:30 to discuss something we don't know. All we know is that Judge Cannone ordered everybody back at 1:30. Marie, what do you think is, do you think that it is something that they need to argue that was brought up at sidebar? It is unusual during the deliberation process to be back in the courtroom, all the parties on the record while the jury's still deliberating.
I think it could be something that requires further investigation. Maybe it was an argument made and the judge needs for her clerk to research it. You know, these things are fluid and the judge has to have more information on something. Perhaps it's a situation like that where they're just arguing about a point and she doesn't know all the details and she wants to inform herself and is using the time to come back and come down with a decision or a ruling.
What's been your experience, Marie, when you hear a jury say, we want to know something about 2.5 subcharge, very specific to the verdict form? Does that mean we're really close to a verdict in this case, or is this something the jurors can talk about at any time?
I think it means we're really close. And I think if they're asking again about the fact that, you know, she was driving under the influence, what time? They want to know, can we consider the interviews as evidence? Nothing on those interviews she said was good on her part. So if they're asking about it, I think Karen Reed needs to worry because it just shows you what it is they're taking into consideration.
There's Karen's coming in right now.
Feeling, Karen? How are you feeling?
No comments right now, guys. Yeah, just give us a little bit of space. Let's get into court.
Any explanation about the 1:30? Is it arguments or?
You know I can't talk, Matt.
That's right. Gag order. You still feeling confident?
Okay. The no comment there, except Alan Jackson saying, you know, I can't say anything, Matt, because of
the gag order on the attorneys. Hasn't been the case for Karen Reed. She has been very vocal there outside of the courthouse and in documentaries and in interviews, and that's one of the things that the jurors had a question about. Marie Pereira, I know we cut you off. Did you want to finish up talking about that? And also the video clips of Karen Reed. That was question number 2. They wanted to know, how can we consider them? What does that language say to you?
It tells me they're considering the statements she made. Did I hit him? Could I have hit him? They're considering how nonchalant she was about the entire thing. And it doesn't look good for her on any of those video clips. So the mere fact that they're asking to look at them and they're tying it up with what time did they draw the blood and how much alcohol did she have in her system tells me they're looking at manslaughter. I'm sticking to that. I don't think that those questions mean, oh, they're thinking about just doing driving under the influence. You can't find her guilty of driving under the influence and not tying together the other charges. And manslaughter takes care of that. No intent is needed there.
Well, you know, to be fair, charge number 2, subsection 5, is just that, guilty of a lesser included operating under the influence.
They gave it as an example, though. They didn't say, we are thinking about this one.
It is absolutely possible for this jury at the end of the day saying, well, we've decided that she's guilty of driving under the influence.
3 years later, and driving under the influence and not hurting anyone. So
right.
not that it's okay
it's a subsection,
in any way,
but it's the only one in this subsection that isn't tied to manslaughter.
Right.
It's sort of off on its own. Is that what they were talking about? We don't know. But what we do know is that at 1:30, the parties are gathering, so let's get our break in. We just saw Karen Reed walk into the courtroom with her defense attorney. Hank Brennan will be there as well, along with Judge Cannone. We'll see what it's all about right after this.
Welcome back. We are on a verdict watch, and we could see that turn into a verdict at any moment. You see right now, the John O'Keefe family returning to the courthouse for that 1:30 appointment time that we understand Judge Cannone asked these parties to come back for. And anytime there's something going on inside of that courtroom, all of the parties gather. And so we're seeing that, all of them walking in. You see Paul O'Keefe there, who has been inside of this courtroom every single day.
Yeah, and just watching them walk makes you real, just we think about what this family's endured. Yeah, the Karen Reed camp also has been through it, but this family has been through much worse. Let's be honest, they've lost so much, including the life of John O'Keefe as they search for justice walking back into the courtroom. We don't know, again, what is happening at 1:30, but as soon as Judge Cannone takes the bench, we will take you into the courtroom. Let's bring in Court TV lead anchor Vinnie Politan and Court TV crime and justice correspondent Matt Johnson, also outside the courthouse. Vinnie, in a lot of anticipation for this 1:30, we will cut you off as we always do if Cannone takes the bench, but take it away, set the scene if you would.
Sure. Something really unusual just happened here. And when John O'Keefe's family was entering, the silence in the streets of Dedham, nobody saying a word. To me, a demonstration of respect for the victim's family in this case. The same exact thing happened when Karen Reed and the defense team walked in. Complete silence in the streets of Dedham. Never have I been at a case where hundreds and hundreds of people are gathering, passionately believing in what they believe in this case, and having everyone silent at the same time. And just before that happened, one of the leaders of the movement, one of the local leaders, got up on the steps behind me to address all of the Free Karen Reed movement members and explained to them and explained a message from Karen Reed herself to her supporters to please, no noise. If the verdict comes down, count after count, please, no audible response. And everyone listened to those instructions. We'll see how it plays out when this verdict comes down. But to me, that was the headline moment that just happened. The entrance of the O'Keefe family, silence and respect. The entrance of Karen Reed, silence.
Judge Cannone is on the bench.
Please be seated. Court is in session.
All right, so I'll see you at sidebar so we don't do this part in open court.
On the record, off the record, still on the record with the court reporter, but now we are back.
Yeah.
Waiting.
Outside the ears of the courtroom and the general public. Not wanting to do it in open court, she said. Don't want to do this part in open court. I'm not, we don't know what this part means, but that was quick. Let's go back in.
Can I have that question, please? Thank you. All right, so as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not the question for it. I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's been clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those two counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
Well, I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question, when we know we can answer that.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor? 1 minute.
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
Wow.
Unbelievable.
Holy mackerel.
Are we having deja vu right now? Is this Groundhog Day? Are we having the same trial over again?
Wow.
I see Vinnie Politan coming up. We got to check in and get your reaction to this, Vinnie. If not guilty on 2 charges, hung on 1. Are we hung on the same thing? Why can't the judge answer that?
I don't understand it. This is now insanity at this point. This is like we're back to ground zero where we were at the end of the last trial. All the controversy about the jury not understanding that they can return a verdict on a charge. They don't have to return a verdict on all 3. If they're hung on 1 and they've reached a verdict on 2, that is a verdict. To not answer the question, why don't you want the jury to know? It's hypothetical? Well, hypothetically, they don't know what they're doing. They don't understand because the instructions are not clear.
Vinny,
Alan
going back
Jackson
to court.
talking again.
Going back to court.
Objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that...
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
allow the court to finish writing, but at this point, that is over our objection. I don't.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't tell you to ignore anything, Your Honor.
All right, we are all set. So let's send this in, please.
All rise.
We have to go back live.
Wow. This is insane. The jury asks, if we find not guilty on 2 charges but can't reach a verdict on a 3rd charge, does it mean it's a complete mistrial?
Why are we using the term partial verdict? We just saw this play out on a national stage in the Harvey Weinstein trial.
Yeah.
The jurors actually returned a verdict. They found him guilty and not guilty on 2 charges, and they went back to deliberate more on a 3rd charge, which ultimately they were hung on. We've seen this play out, so I'm not understanding why that can't happen here.
Insanity. Let's get to Vinny. He's shaking his head. Help us, Vinny. What's going on there?
I'm at a loss. I'm at a loss as to why this is so hard. This is not hard. The jury doesn't understand what a partial verdict is. That's what they're asking. They're asking, can we return a verdict on a single charge, or do we have to return a verdict on all 3 charges? That's what it is. The judge is saying it's hypothetical. That could be semantics. That could be just the way they're asking. Like, people speak differently. Like if we're not guilty on 2 of these charges, and we're hung on the 3rd, it could be semantics. Like, let the jury, we all know what the jury's problem is here. They don't know if they have to return a verdict on all 3 for it to be a verdict. It was the same thing with the first jury, if you believe the people who came forward and filled out affidavits and spoke to me on the air. I don't understand how we can be in the same exact place without providing, what were we talking about? Clarity. These are 12 people who have never tried a case. These are 12 people who maybe never picked up a law book. These are 12 people who, God forbid, never watched court TV. My goodness.
Who got through
give
the
them some
selection process in a case that had intense media coverage. So, of course, inherently, you would think that these people don't know the system.
Vinny, are people reacting in a way that, we just heard, sorry about that. We do have to get to a break. I've got to ask you a question about whether people see these not guilties as actual not guilties. Let's get to a break. We will check back in with Vinny after this. Stay with us.
Tonight on Closing Arguments, it's the retrial of the century, and we're live from Dedham with all the Verdict Watch updates. We're bringing you the latest insight as the jury deliberates Karen Reed's fate.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
The brutal murders of 4 University of Idaho students.
Detectives arrested Brian Kohlberger.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
In on another case in South Carolina that you're not going to miss a moment of the Karen Reed murder retrial. Stay with us.
Michael Colucci on trial again for the murder of his wife.
This is just not an easy case.
Colucci's first trial ended with a deadlocked jury.
We may never know what happened that night.
The Garden Hose Murder Trial. Live coverage today on Court TV.
Tonight on Closing Arguments, it's the retrial of the century, and we're live from Dedham with all the Verdict Watch updates. We're bringing you the latest insight as the jury deliberates Karen Reed's fate.
Closing Arguments tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. Before we head back up to our roll-in coverage of the Karen Reed case, breaking news out of South Carolina. A judge has just dismissed the indictment against Michael Colucci without prejudice in a case that we were set for closing our opening statements to start this afternoon.
Yeah, Michael Colucci, he was accused of strangling his wife, Sarah, outside of the family jewelry store back in 2015. He had a first trial in 2018 that ended in a hung jury, and now this one is over as well.
Yeah, let's listen to the judge dismissing this indictment moments ago.
The beginning of a new trial is exactly where we find ourselves today. The state argues with some authority and precedent that basically this court should treat it as the equivalent of no harm, no foul, and that now that this information is known, it can be presented to the jury who can evaluate it and give it whatever weight it determines it deserves in arriving at a verdict. Indeed, this court believes that it is a choice among several that would no doubt be upheld on appeal if this trial were to go forward and the defendant was convicted. However, this court believes that our courts should demand better from the state, and to simply allow this trial to go forward with so many witnesses, such as pathologists, having been denied the opportunity to have this critical knowledge available to them when that material was fresh, amounts to a foul with a harm. Therefore, this court is quashing this indictment without prejudice and ordering that if the state wants to retry the defendant, it is to do so only after the case has been resubmitted to a grand jury who shall have the benefit of the full measure of evidence this matter deserves. This court recognizes this is an unusual remedy. However, this is an unusual case. This court urges the Attorney General to present a fuller case to the grand jury than is usually done in state court in South Carolina. The goal is to do justice, and this case deserves a fresh restart in order that the citizens of South Carolina can have full confidence in whatever the jury's verdict may be. It is so ordered. All right?
Thank you, Judge. We are grabbing an exhibit to supplement into the court record of a text message that was shared on May the 12th, which would have been, I believe, the same day that they're alleging this happened, where the victim said to Michael, "I'm telling you that I love you. I'm shooting myself in the woods." That is a specific example of her saying that she's going to kill herself, which was one of the reasons why you stated that, Judge. So we just want to supplement that into the record since that was turned over in 2016 to them as well. So we're adding that as a court's exhibit.
All right, there you have it. The Garden Hose murder retrial is no more. The judge dismissing it without prejudice. So that means that there is the opportunity for these prosecutors to try another retrial.
Yeah, that's probably not going to happen given it's been 6 years to get to this point. It's another case. Let's go back to Karen Reed. We are waiting anything. We're waiting for any word from that jury in the Karen Reed case. It's 13 hours, 54 minutes, almost 14 hours of deliberation, and it's been quite a day. If you're just joining us, there have been several questions from this jury, and the last question of 4, at least the last one we have heard about, was basically, hey, Judge, if we find her not guilty on the top 2 charges and can't figure out the third, is this a complete hung jury? What should we do? The response, sorry, can't answer. That's a theoretical question. Our lead anchor, Vinny Politan, among the folks outside the courthouse. And Vinny, as every second ticks away, the anticipation grows.
It absolutely does. And I want to give you, Ted and Julia, an idea here of what's happening at the courthouse. So we started here at the top of the street, which I call the gauntlet. We're going to walk through it so you can see the number of people and how far it stretches. You've been getting sort of a snapshot. I want to give you the full picture as we walk and talk here. As we make our way down the street, you can see folks lined up on the left. These are the folks who get the shade of the tree, and in case it rains, they're protected. These folks, VIP, in the benches that they have. You'll notice the similar colors. Almost everyone is wearing some shade of pink. And now we get to the part you start to see more and more American flags that were being handed out. This is sort of the epicenter across the street from the courthouse steps. Folks have been gathering here. Law enforcement's done an amazing job in communicating with everyone what expectations are if and when a verdict comes down. But you can see I'm moving a little more slowly now because there's many more people gathered here. This is an area, again, you can't chant, you can't show your signs, but you can see the density of the crowd in this area, which is just across the street. These are the steps that we've been broadcasting from. My show, Matt Johnson. We come down here. This is the grassy knoll that I've been talking about, the area under the tree. It goes back 3. You got to be here early to get these seats, but folks have gotten them. There we go. You've got more folks up here going 1, 2, 3, 4, 5 deep in this area. Best dressed always. Good, good. And we move down the street. We're still in the buffer zone. So we're still inside the buffer zone. We've just cleared, if you look, we just cleared the courthouse, right? So now we're getting to the area close to where you can see Matt Johnson is over there. If you look in the distance, you can see Matt. Matt's getting ready. He's across from the folks who get the closest to Karen Reed and her team. We've got more folks here. Again, still buffer zone. Still buffer zone. Great area over here. Lots of lawn chairs. People have a seat. People getting to know each other. A lot of them know each other already through this and other reasons. Now, as we cross the street, it starts to thin out a little bit. But it's not quite over because I'm going to show you the end of the buffer zone as we keep walking down. Now, during the trial, there were many more people down in this area because this is where you could wear your shirts and people were watching live streams of the trial. But you have people lined up down here as well. And the further we go, the closer we get to really what was the epicenter of the supporters during the trial. As we move down here, it's a little more comfortable, less crowded, but you're still not far from the courthouse. If you turn around from here, you can see where we are in reference to the courthouse. It's still not far, and you cross the street right here if you want to get into the part that greets the defense team and Karen Reed when they show up in the SUVs. And obviously, folks who are sitting here will be able to see those SUVs arrive. And when there's a verdict, that's going to be one of the indications when the defense team or John O'Keefe's family enters the courtroom once again. Down here, folks got some coolers. Looks like you might have a rubber duck or a chickie or something going on over here. Not quite sure what that turtle or frog means. Turtle, there you go. And then down here, this is really the heart of, during the trial, day in and day out, the folks in this area who are allowed. Because right here, this is the sign. We are now exiting the buffer zone. Okay, so this is I guess the non-buffer zone or the buffer-free zone. And here folks can do whatever they want to express themselves with their shirts and signs and making noise. So that's the entire gauntlet. Back to you guys.
Wow. Thank you, Vinny, because that does put it in perspective.
Just how big it is,
Yeah.
the area to the buffer zone. We'll be checking in with you. I feel like a verdict is coming right around the corner. Let's bring in another Court TV anchor we have in studio with us. Judge Ashley Wilcott is with us. Judge Ashley, what does this mean about the prosecution's case? This is the second time around that they have attempted the same charges. They didn't change things up, even though they knew that many of these jurors from the first trial reported we are not guilty or we were not guilty on second degree and leaving the scene real quick.
So some people think that the murder in the second degree is too big of a charge, too much of a charge, the intent piece. The Commonwealth may start to feel that way soon.
We'll see. Let's get a break. More of our Karen Reed rolling coverage from Dedham, Massachusetts, and across the country. People are watching. Look at the clock. 14 hours now. The jury has been working to determine the fate of Karen Reed. Have they come to a not guilty verdict on 2 of the charges? Sure seems like that. Back with this, more after this.
Welcome back to Court TV Live. I'm Julia Janae along with Ted Rollins this hour. We are continuing to follow the breaking news that's happening in Dedham, Massachusetts with the Karen Read Verdict Watch. But we also have some breaking news and a verdict in another live trial that we've been following here on Court TV and CourtTV.com.
Yeah, Megan Jackson was on trial for plotting with her lover to kill her boyfriend. The verdict has just come in. Let's watch.
Indictment number 2021 GS 2601191. The state of South Carolina, county of Horry versus Megan Marie Jackson as to the charge of murder. We, the jury, by unanimous consent, find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
I let the record reflect that all the jurors raised their right hand. Any opposed to the jury by the defense? No, sir. All right. Ladies and gentlemen, I want to thank you for your service. That will conclude your duties as jurors in this case and for this term of court. I want to thank you for your service. I know jury duty is not a fun thing to do, but it is an important thing to do and a vital thing to do. You have a 1-year disqualification from serving as jurors in state circuit court. You've had a 3-year exemption. I hope you don't exercise your exemption because we do need good jurors. And I want to thank you for your service. You're free to go at this.
All right, Megan Jackson found guilty in South Carolina. If you're interested in more of the coverage, we're continuing to cover it on CourtTV.com. But guilty, she decided not to take the stand in her own defense.
Right, justice for Gregory Rice, the father of her children, one of those daughters taking the stand very emotionally, talking about how her mother acted after this. Again, CourtTV.com, you can watch that trial. We haven't been able to play it as much on air because we have been fully in the Karen Read murder retrial, where we are still in a verdict watch.
Let's head out to Dedham, Massachusetts, where we find again Matt Johnson, who, along with the rest of us, frankly, is just waiting and waiting, along with lots of people around you. Matt, fill us in on the mood.
Yeah, the mood here is everyone is pretty much very quiet right now as we're waiting for the next move, maybe the next car to pull in here. So we're actually in a restricted area where it's not open to the general public. This is where those SUVs that Karen Read arrives in and her attorneys, they drive right here, and this is across from the main buffer zone area, or where all of these supporters have assembled across the street. So I want to give you that other perspective from across the street. You saw Vinnie Politan walking through the crowd over here. So this is directly across from the courthouse. This is the Registry of Deeds. You see the majority of supporters are over there. Well, across the street and over this way, you have District Court. They're also over there. That's where that buffer zone originally had come to an end. There were signs in place. It has since been relaxed in a sense, as long as supporters are quiet and not holding signs or T-shirts that directly affect or are part of this trial. You have these supporters that are described as the ones that are closest to Karen Read when she gets out of her vehicle, and also the O'Keefe family as they make their way to court. But what I also want to show you is, aside from all of the police presence over here, just how close these supporters are and these supporters are to the courthouse in relation to the courtroom. So this is the courtroom where the trial took place. And this is why it's so important to why everyone is quiet out here and they maintain decorum, as these 12 individuals that are deciding the fate after this 8-week trial can do so in silence without influence. I'll send it back to you guys.
Matt, have you noticed everyone keeping it with those rules? It does seem like it sounds a lot quieter than we used to hear outside.
It is completely quiet out here, and we noticed that change, especially as jury was seated, the deliberating jury, and then also those deliberations began. These individuals want to be here to not only witness history, but see a resolution, and of course, they're out here supporting this defendant, Karen Read, but they don't want to be pushed back or removed from this lifted area that is still under court order and under restriction, but they can assemble here as long as they're quiet and don't have that signage. Otherwise, they can be pushed back to where Vinny had shown you, where the original buffer zone for trial number 2, the retrial, began.
Okay. Thank you, Matt. I love seeing where the actual courtroom is. Hey, Matt, is that a black SUV in front of the courthouse?
Let me see. Let's walk over this way. Let's take a look. Let me see. Usually these officers would be getting on their bicycles. We would be seeing the media over there. They would be grabbing their cameras. I'm not seeing anything come down, but this is the direction of traffic where these SUVs would be coming in, and then they would make their way past where my cameraman's standing. So no, but good looking. We'll keep an eye out for you, and we'll break in.
It might be just someone on their way to the Logan Airport there in a limo.
Right.
So let's bring in Judge Ashley Wilcott. And Judge, the importance that, Matt did showing us the proximity from the courtroom to those protesters. We've covered cases. Harvey Weinstein, you could hear the thumping of the drum outside of the courthouse in Manhattan. Michael Jackson, same thing. It does make a difference, does it not? Because this jury, if they know that they are being pressured to go one way or another by public opinion, it can change their thought processes. And say what you will about Judge Cannone and her handling of some things in this case. How did she do on managing this, which is quite a task?
Listen, I agree with you, Ted. The noise factor can really distract a jury. So even if it doesn't sway them one way or another, it can make them anxious, it can make them uncomfortable, it can be traumatic for them. So it's good to keep the noise down. Beverly Cannone really did. And remember, the buffer zone, you weren't even allowed to be there. And then they, supporters, took it to court to get a different ruling to say we can be in the buffer zone, but they can't use certain signs. They can't wear different pictures. They have to have, that's why they're doing the love sign with their hand and sign language. They're having flags because, of course, that's something they can hold. So I think this is a good compromise because I did think, you know what, people should be able to stand there, but they shouldn't be able to cause a distraction for the jury. Now, I have to say this, too, though, Ted. I am wicked impressed with all of these people and how much they are following the rules because we don't always see this. And people are going to yell and scream and react, even in courtrooms when a judge says no reaction to the verdict, and then you hear roars in the courtroom when the verdict's read. So this crowd is really managing itself very well.
I love it. Wicked impressed. That's great for Boston.
Oh, for sure, that is. I see Matt Johnson moving. Something may be happening, but let's slip in our break. And we will talk about not only what's happening there on the ground in Dedham, Massachusetts, but also what could happen. We'll have some hypotheticals of our own if this case goes one way or the other. That's next.
Tonight on Closing Arguments, it's the retrial of the century, and we're live from Dedham with all the Verdict Watch updates. We're bringing you the latest insight as the jury deliberates Karen Reed's fate.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
The brutal murders of 4 University of Idaho students.
Detectives arrested Brian Kohlberger.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
Welcome back. Verdict Watch continues to march on in Dedham, Massachusetts. You see there we have a camera inside of the courtroom there, and the fan is still going and the jurors are still going. 14 hours and 16 minutes so far over the course of 3 days.
It's been quite a day today with 4 separate questions from this jury, and now a lot of anticipation because of those questions, leading to many people, including us, that a verdict may be imminent, or at least another question, some more clarification from this group. Let's bring in Court TV lead anchor Vinny Politan, who is outside of the courthouse. Vinny, I understand you have found a couple John O'Keefe supporters who outnumbered maybe outside of the courthouse, but there are plenty of them across this country.
Yeah, absolutely. And obviously at Court TV, we cover every side of every story that we can. And outside the courthouse, since I've been here, the story's been the sea of pink. We've seen that. We've seen it grow. We've seen it emerge. But I was able to find 2 folks who are showing their support for the victim in the case, Officer John O'Keefe. And I want to speak with one of them right now. How's it going?
Good. How are you?
All right. So first, explain your thoughts at this moment. You know, being here, wearing Justice for John O'Keefe badge, outside of a sea of pink.
Certainly outnumbered. That's a fact. I think it's about 200 to 1. I think we're looking for closure. I think everybody's looking for closure at this point in time. I certainly feel strongly about the Commonwealth's case. I feel like they did a phenomenal job. I feel like the data is the data. I feel like this is a very simple DUI homicide case. Whether or not she intended to do it or not, I believe that's up for debate. But I think the prosecution certainly presented a very, very strong case. And I quite honestly think the rest of it on the defense side is just a smokescreen. That's my opinion.
And your thoughts about, you know, walking with this sweatshirt on that you're wearing?
Yeah.
Has it been a problem at all, being here at the courthouse?
I've had a couple jeers, a couple cat calls. Nothing violent, nothing harassing. Everyone's been fairly kind, but yeah, I've had a couple of people say some things, and I just ignore it. I knew that was going to happen, though, you know, and it's a volatile, emotional situation. I get it. I understand it. They're supporting Karen, and they feel that she was, you know, unjustly accused of this crime. So I understood that coming here and, you know, kind of being an outsider and a one-off, that I was going to subject myself to some of that. But for the most part, Vinny, it's been fine. People have been great.
And are you surprised that more people haven't shown up like you? Because you're not alone. I mean, we've seen and heard from plenty of others. Obviously, the public numbers here at the courthouse, predominantly, I mean, almost exclusively pink. But are you surprised more folks like you haven't shown up?
I don't. I think, you know, obviously, a lot of these people are out here for a reason. I think a lot of the supporters for John O'Keefe and their family, they're at home, they've got jobs. I'm not trying to belittle anybody here and say they don't have a job, but I think that I'm from the West Coast. The people that I talk to in my home state and the surrounding states, and I've got a daughter that practices law in the Midwest, they all think this is a very simple case and a very simple outcome that should be, and don't believe in the conspiracy theorists and the conspiracy theories. But I think because people don't want to get involved in this sea of pink, they stay away. And that's my opinion. That doesn't mean I believe that when I see these polls that are skewed in crazy numbers that I believe those numbers are accurate. I just think that people, you know, choose to support him from afar.
I appreciate it. Thanks so much.
Thank you.
All right. So I think it's a real accurate reflection of what's happening. You know, the level of passion that you have for it, what are you willing to sacrifice to bring here, right? There's folks that have to work, folks have to do things. A lot of folks here are using vacation time. Some have traveled from out of state, like the young man I spoke with. It's a case where everyone has an opinion, and fortunately, I think part of the lesson of this is that everyone should be able to express that opinion. You should be able to, every trial we cover has at least 2 sides, right? Every trial has at least two sides to it. And there should be a vigorous debate. People don't have to agree, but there's not really a reason to be disagreeable about it. There's a reason why we have trials. The reason we have trials is people don't agree as to what happened and what should be done as a result of what happened. And we bring in a jury to decide it. And hopefully that's one of the lessons that gets taken away from all of this, and hopefully there aren't any brush-ups between the two sides. I know last year we had one flare-up of some shouting back and forth late in the case, but we haven't seen that here. But primarily we haven't seen it because the other side hasn't really been here, but there are plenty of people who believe in the prosecution.
Talking about two different sides here, and I'm curious as to how you think this compares to other cases in terms of how split people are. I mean, we cover verdicts almost every day. Every week there are verdicts that come down, but it's rare to find one where people are so split that it almost feels similar to an election, where you know there's almost a chance that it could go either way. It feels a little different now that we've gotten these notes from the jury, but your thoughts on this case and the dynamics of it?
Yeah, I think, and to be honest, looking back at all the years at Court TV and all the big trials, the trials that touch the public, a lot of them swing one way. Usually it's to the prosecution. It absolutely is. There have been some that were very split. Kyle Rittenhouse, very split. The Menendez brothers, originally going way back, was split. That was split down gender lines. Kyle Rittenhouse was political lines. So we do see some cases like that are split. This one, it's tilting one way. It's tilting not guilty. It just absolutely is, from the people who are voicing their opinions, right? That's the only way you can gauge it, is from people who are expressing their opinions. There may be other people who believe in the prosecution but just don't express it. And that would be sad if they wanted to express it and they couldn't, afraid of what the response would be. That's the system not working, right? But if we go by just what people are expressing and have expressed in other cases, this is one that's swinging all the way in one direction, which brings me to a question that I have. In the day that we live of social media, where people are very outward about what they think about a case, is public opinion in sync with what the jury is seeing inside the courtroom? And we only know after the verdict. Johnny Depp, they're going into Johnny Depp. I had no idea where the public was going to land on that. I should have known, because Johnny Depp is a world-famous celebrity, but it was overwhelmingly on Johnny Depp's side, and it grew during the course of the trial. And in the end, the jury agreed with what the public was seeing and hearing. We'll see in this one if that's true as well.
That's
to
a
me,
great
that's
point.
the variable that we have now.
Let's talk logistics here. This jury has till 4:30 today. As much as we thought, we're heading to a verdict, it is coming up to 3 o'clock Eastern time. We're talking about another hour and a half. Do you think they are now back there trying to decipher whether they can come to an agreement on that third charge, if indeed their hypothetical letter to Judge Cannone was accurate? And if they don't, is it possible we're back here tomorrow?
Yes. Okay. Yes and yes. Yes, I believe they're debating that one count. The hypothetical, I'm not buying the hypothetical. I think it was semantics. It can be interpreted either way, if da-da-da-da-da. I think it's just the way you speak, and you might write out a question the way you speak. But why would you send out a hypothetical about reaching and saying the words not guilty? Because the judge and the lawyers are all going to read that. Why would you hypothetically send that out unless you're really, really cruel to a certain extent, right?
Right. No, I agree.
I agree
totally
whatever the verdict is, when it's completely hypothetical, that would be cruel to do.
But they can't finish this today, Vinny. They won't be able to finish. They're not going to have enough time because there hasn't even been an Allen charge or anything to push them back on that third charge. We're still a ways away.
Right. Right, except if they are on the operating under the influence. If it's just the least of the lesser includeds, if it's just OUI that they're debating, you can fold a lot quicker on that. Whichever side you're on, you could fold a lot quicker on that. And that's one where you could clearly compromise, because people understand the difference between OUI and murder.
This jury, so close. We can feel it. We're all watching together. Vinny is there on the ground. We aren't going to go away from this trial today. So you are with the best network to cover the Karen Read Murder Retrial Verdict Watch. Don't go anywhere. We're slipping in a break. We'll be back.
Mr. Reed, any comment?
Not really. Not really.
How are you spending the deliberation time?
In prayer, and, you know, that's about it.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott here with Julia Janae because it is all hands on deck. Thank you for staying. This is a huge day. The fate of defendant Karen Reed remains in the hands of a jury. We are in Dedham, Massachusetts for verdict watch in Reed's murder retrial. She is accused of killing her Boston police officer boyfriend, John O'Keefe.
And we're giving you now a live look inside of that courtroom where the jury has been deliberating now 14 hours and 30 minutes over the course of 3 days. Because the camera's on that fan, that means that there's nothing going on inside of the courtroom in terms of being on the record, but when that changes, we will take you there live. Let's bring in Court TV lead anchor Vinny Politan, who is down in the middle of it all, on the steps, in the buffer zone. Vinny, what a moment this is for the jury to send this hypothetical that could all but answer the questions that people have had since the last trial, and we just wanted an answer in this case, but here we are, still waiting.
Yeah, I think we have to take the words of the jury for their words, right? I am under the presumption that they've reached not guilty verdicts in 2 of the 3 charges. I think they're extremely close. I think they're caught up likely on count 2, which is the most confusing of all the counts, the one they ask questions about. I've also noticed, I just have to tell you in the last few minutes, sort of a shift in the winds here. It's getting a little darker, a little cooler. I feel like the rain may be coming down, could be symbolic that we are getting closer to a verdict, right? Just reading into the mood here. But the anticipation of everyone is growing each minute we get closer to that time. And let me show you where everyone's eyes are. Just across the street behind that white SUV that you see over there, that is the area where Karen Reed and her team pull up when they are summoned to the court. And they will be summoned when and if there's a verdict or another question, or to come because it's the end of the day. I would expect them to be here around 4 o'clock or so, because they'll probably check in with the jury at that time to see how long they're going to go. But if they are hung on one of the counts and they haven't sent a note yet saying they are hopelessly divided on that issue, on that charge, then things just move along. And I really think, based upon the response to those questions that they had, they may be trying to figure things out for themselves. Like, what do you do when you send out a question asking, can we reach a verdict on 2 of the counts and be hung on the 3rd? Is that still a verdict? Is that a hung, or is that a hung jury? What is that? And you get no response. What do you do? I think what you do is you plow through the one you're hung on, because you know for a fact that if you reach a verdict on all 3, that is a verdict. Like, they know that. So I think that may actually, in an indirect way, make them work a little bit harder at this point. But I think that's the hope of everyone here. And I think everyone here is believing that if they reach a verdict on that 3rd count, it will also be not guilty. But we shall see. This is an unusual circumstance, right, where you kind of get an inkling that maybe the jury has found someone guilty before, not guilty, before it's actually announced inside the courtroom.
I would say this, Vinny. I think that if it's not guilty on all of the charges, except for the lesser included offense of operating under the influence of liquor, that would be a big win for Karen Reed. Of course, she wants an acquittal across the board. But I must ask you this, because I don't know that I necessarily understand. Judge Cannone said it was a hypothetical question. I cannot answer a hypothetical question. Do you think, though, that possibly an answer could have been provided to simply say, yes, jury, you may have independent verdicts for each count, so that there's clarity?
Wow, that sounds like a judge wrote that, Judge. Listen, yes, that's the obvious answer. It's not really it's a question of law. They don't understand the law on what is a verdict. They don't know what a partial verdict is. No one told them what a partial verdict is. Here's an opportunity to instruct them. Would it be improper in Massachusetts to let the jury know what the law is? If that's the state of the law in Massachusetts, they need to change it. Like, if 12 people who know nothing about the law can't ask a question about what is a verdict, then we've got a problem. We really have a problem. So we'll see how it all resolves itself. I think the easiest resolution, the cleanest resolution, is for the jury to work it out. But I'm with you, Judge. A clear legal instruction about, yes, you can reach a verdict on each individual charge. And you don't have to say an if. You say you can on each individual charge. So a verdict on count 1 is a verdict on count 1. A verdict on count 2 is a verdict on count 2. A verdict on count 3 is a verdict on count 3. If you're hung on one of them, then you have 2 verdicts and 1 non-verdict. Like, just explain it. Make it easier, not more difficult. Why do we do that to citizens? They were summoned down here. They didn't sign up to be jurors in a murder trial. Make it easy for them. I think our system is getting it wrong right now.
I agree with you, Vinny. And they're lay people. These are lay people. They're not going to interpret every word like we trained lawyers have done because we're trained to do so. So, Vinny Politan, thank you so much. I understand you're going to keep, of course, updating us throughout, letting us know. Oh, good. I can stay with you. I'm so sorry. I thought that we had to go from you because of some other things happening there. So I do want to ask.
I'm not going anywhere, Judge.
Yes.
Judge,
Yes.
I'm not going anywhere.
Yes.
I'm going to be here till there's a verdict.
And listen,
that's why I'm here.
I'm so thrilled to have you because your expertise, the feel that you've pointed out of these individuals are so quiet, supportive of Karen Reed. And in fact, we know Karen Reed did send a message that said, please stay silent. Don't cheer when there's a verdict. Please respect that. Do you think they're going to be able to do that, Vinny?
I think so. It's interesting because there's a natural ambient noise when nothing is happening, right? There's the rumbling of just hundreds of people gathered in a public place having their own private conversations back and forth, but it raises the volume a little bit. It's not chanting, it's not screaming, it's just natural conversation. But then when the attorneys walk in or the O'Keefes walk into the courtroom, there is no sound. There is zero sound in those moments. So I think this crowd is understanding the power of silence, and I think they will abide. I don't know. There's hundreds of them, so there could be a few that say something, but I think the overwhelming majority of them will remain silent in the moment when they all go to their cell phones and listen and watch the stream of what's happening inside the courtroom. And they're all going to experience it separately, but almost at the same time. Because it's funny, when you watch a stream, some are a little more delayed than others. So people watching, some will find out a little bit more before others, whether it's guilty, not guilty. But if everyone remains silent, then everyone will be able to hear.
It's amazing that there's that kind of cohesion, because sometimes with a group that large, I mean, I've been hearing a number that's close to 1,000. I don't know if that's the same today, Vinny, but to have everyone on one accord, someone to be able to come out and deliver this message for Karen Reed to them, and for everyone to abide by it, for not just one group to be quiet, but everyone to be quiet. I don't want to talk about this note and what happens now, what's happening now, because I've gotten this question from some of our viewers. If the judge it made some kind of error, this is a hypothetical, in not explaining to them what a partial verdict is, and they come back with guilty on that charge that they at first were saying they might have been hung on, do you think that that's an appealable issue? Let's say they come back with something even higher than the DUI, something that really could carry some prison time.
Yeah, I think it would be an issue. I think it would be raised. I don't know if it would win, though. I don't think it's necessarily a legal error to not answer jurors' questions, right? I think there's a level of discretion in there, so it's not a legal error, but I think it's an error in our system. And I think it's an error in trying to help 12 people understand what they're doing, so the verdict reflects what they're actually deliberating about and what their agreement is for them to understand. I think it would be on top of the list of their issues, but I don't know if it would necessarily be a winnable issue, because the judge's instruction was a non-instruction, so she didn't do anything to err in the way she instructed them. You know, what she said is probably legally sound, but does it help the jury? No. Does the jury need help? Yes. And that's the problem. And I think that's where things are not in sync right now in this courthouse. But like I said, the remedy to all of it is to reach a verdict on it. And you know, we're all looking at it and thinking it's perhaps the OUI because they mentioned that in their series of notes, you know, trying to get more understanding about it. If it is, the irony of all that is if they get hung on OUI, if there's a third trial, like a retrial, she's not just facing OUI, she's facing manslaughter because that's the top charge in that count. So if they can't agree to anything in that second charge, she faces manslaughter again. Because in the first trial, the jury was debating involuntary manslaughter. They had gotten past manslaughter. They didn't think it was, but she's facing manslaughter again.
So you're saying Judge Beverly Cannone's decision there actually benefits the defense in the long run, because if they come back and push for that OUI, then that's it. They can't come back with that manslaughter.
I think that's true. But Vinny, let me push it backwards a little bit, because to me the potential legal issue is the jury instructions and or, again, the form, which is called a verdict slip in the state of Massachusetts. We have a copy of that. So I think that arguably maybe there should have been more. It should have been made clear there. Is that a potential legal argument? Because I am astounded and would love for you to weigh in on the fact that we're back here again this trial, because this is not, I think, where anyone thought this would end up.
Yeah, I think all of us have looked at this, and I've got mine here. Obviously, it's been amended since today, but it's a little confusing. It's a little messy. It's not 100% clear, but if you read the actual words of it, as a lawyer, it makes sense, right? But you really got to read it again. But we're in such a different place than 12 citizens. The problem is, who will be interpreting that verdict slip? It'll be judges and justices. It's not, you're going to grab a person off the street, take a look at that and say, does that make any sense? It's going to be a justice or a judge who's going to read it, and they're going to say it's, my personal opinion, they're going to say it's fine. Like, it might not be the best, but it's not wrong. If you read the words right off the top, not guilty of the offense charged or any of the underlying charges as well. So the words are there. The way it reads to someone who hasn't covered trials for more than 2 decades or hasn't been practicing law for 30 years or who doesn't wear a robe, it might not make sense. And that's the problem. That's the problem. And it's really showing its face because 2 years in a row we're in the same place. 2 years in a row. How does that happen? Something's wrong. It's not the jurors. These are 12 different people who are just as confused as the first 12.
Yeah, I like that you pointed out it's justices who make that decision looking at that form, and you're right, that's a different perspective than a layperson.
That's absolutely true. It's unbelievable that we are here. I remember when we were hearing this question that, for good reason, but Judge Beverly Cannone didn't let it come out initially when we heard that smattering of 3 questions. She waited until 1:30 is what we believe. We do have to slip on a break, but we are going to keep you posted on everything that happens in this Karen Read trial. We have you covered inside, outside, on air, online. All Karen Read until we get this verdict from the jury, who has indicated they may be hung on one of the charges. Stay with us. You're watching Court TV.
Tonight on Closing Arguments, it's the retrial of the century, and we're live from Dedham with all the Verdict Watch updates. We're bringing you the latest insight as the jury deliberates Karen Read's fate.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
We're getting you ready for the biggest trials across the country before court is in session. Plus, deeper dives into true crime stories with our daily spotlight.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Welcome back to Court TV Live. We're in a verdict watch in the Karen Read murder retrial in Dedham, Massachusetts, and we're getting word that there may be some movement happening in front of that courthouse. Let's go out live to our lead anchor, Vinny Politan, who is there on the ground in front of everything, and let's see if he can tell us what is happening that is changing there.
Okay.
Vinny, can you hear me? If not, we will wait.
Yep, I hear you.
All right.
I can hear you. I can hear you, Julia. I'm off camera just so you can see what's happening here. We haven't gotten any word about anything, but I don't know what's going on. But everybody is now crowding closer and closer to the street. They're more densely packed. The area where the defense team shows up is now filling up. It just appears to me that something is happening. Something is happening. There's been no official word. And I think what everyone is anticipating perhaps is keeping their eyes to see if the defense team shows up or if the O'Keefe family walks into the courtroom, because that would mean that something else of significance is happening. We know where we've been all day. We know what is potentially happening, which is a potential verdict today. So I think the level of anticipation is peaking right now. More so than at any point today or yesterday. So we are on standby, keeping our eyes open to see if the defense team shows up in their SUVs or if the O'Keefe family shows up and enters the courtroom. So we're keeping our eyes on that right now.
Vinny, I will say it sounded like for a moment it got kind of loud out there and then it died back down. But my question for you is this. Do you have any information to know whether or not Karen Read, who's not under a gag order, lets her supporters know if she's headed back to the courtroom? Is that allowed? Does she do it, or do we have any idea?
I think it depends upon the nature of the communication from the court. If the court says you're not allowed to disclose information for security reasons about whether or not there's a verdict or not, then maybe not. If it's something that's not protected, she could. I don't know if that communication is happening, but all these people that you see are all very connected. A lot of them are getting their information from similar sources that speak to one another and are constantly on social media. So in the world we live in now, if information, and it's a big if information like that does leak or is given to one person, hundreds of people are going to know that information very, very quickly. That's the nature of the world we live in, but also the nature of this case and this Free Karen Read community that is at the courthouse.
I can only imagine the anticipation that everyone there feels, because there is really nothing like a verdict watch, waiting for a verdict to come down, whether you're someone who is actually a party, a family member of the victim, or these supporters that have become very invested in this case. I mean, this is just everything they've been waiting on, not just for the entirety of this 30-day trial, but since the first trial, since this happened, and people realize this might be something that equals collusion or corruption. I mean, I can just only imagine what they are thinking in this moment. But I would imagine, Vinny, after the things that we have heard from this jury, it's not a lot. We only heard one round of questions from them, but I can imagine that they are ready to hear the words that they've been hoping this jury would come back with.
Right. And if you can see the woman with the aqua-colored glasses who is recording all the supporters, she's the one who addressed all the supporters to ensure at the moment of a verdict that they remain silent. And she's the one who gave the message from Karen Read. So that's someone who is getting information directly from Karen Read. And right now at this moment, she's taking pictures of everyone. I haven't heard her say anything about whether or not she's gotten word from Karen Read about what's happening, but she's taking this moment to walk in the street to record all the supporters lined up at this particular moment. So that's what's happening right now. But again, it's kind of interesting to see where everyone is right now, because it's not 4:30, it's not the end of the day. The attorneys usually show up pretty close to this time, but this is a little early for that. So if they show up right now, I would think it's something other than just the end of the day. I'm seeing some deputies walking down the front stairs right now. I can also see Matt Johnson in place across the street as well. Not sure if they're just leaving for the day or securing something, but there's a intensity that you can feel here at the courthouse at this moment. So if I was watching at home right now, I would not leave the television. I would not leave the television right now.
Vinny, I'm in pins and needles. I mean, honestly, I will not leave the television, whether I've been watching all day. I honestly cannot turn my eyes away. So in looking at this crowd, waiting for a verdict, yesterday we were talking about really the routine that this jury is accustomed to. You just mentioned it, 4:20, they'd go home every day. During deliberations, they've gone home around that time. Do you believe, you've seen huge trials with juries, do you think it's true that they are in a little bit of a routine, so they're probably inclined to either finish it by that time or come back tomorrow?
Yeah, I think that's the way it's been operating. And after months of operating that way, I think that's the way it's going to go. And there's limitations here because the security staff has to clear the building and shut down the building at a certain time. They don't have the same flexibility here in Norfolk County, Massachusetts, that we've seen in the dozens and dozens and dozens of trials that we've covered in Florida, where the judge is in charge of the courthouse. Here, security runs the courthouse. So the judge does not keep them past a certain time. I think they shut down by 5. They try to clear everyone out before then. So that's the way it's been going. But the gathering of these people is before that moment, right? I don't have a clock in front of me. You do.
3:22 p.m. So we're at least
3:22.
40 minutes
Yeah, this is like an hour before that time.
Mm-hmm.
Yeah, this is way before then, right? So my gut tells me if people have gotten word that something is happening, and it's come from a source within the defense team or elsewhere, it has spread very quickly. And everyone is here. Everyone is anticipating a verdict at this moment. I'm being honest with you. That's what everyone right here, you look at all these folks, that's what they believe is about to happen. We have gotten no official word, and we have not seen the O'Keefe family or the defense team and Karen Reed arrive. But if they're en route, maybe there's someone who saw them get into their SUVs.
Look at how many people, Vinny, you've described it, but when you see these pictures, it's crazy how many people are there. All right, that
and
verdict.
They're all standing.
Yes.
They were sitting earlier, but they believe something is happening. As we see these cars go by, I know they're all just waiting which one is going to be the one that may have the defense team inside, or even the O'Keefe family. Let's do this. We have to get to a break, but now is a good time. We know that we're on this verdict watch, and a verdict could come down at any moment, and certainly the people outside believe it's coming soon.
That's right. We'll be right back after this very short break.
Jurors are entering. Court is back in session. You may be seated.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it, so please just clear your heads. Don't think about this case at all as best you can, and we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for court, please. Jurors follow me. Jury's exited the courtroom.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is adjourned.
Now everyone's falling out, and they've got to come back another day. Karen Reed's got to come back another day. John O'Keefe's family has to come back another day. This case is not over.
This case is not over. We are out of time. We're going to take a quick break. Vinnie Politan, thank you so much for being with us all day long. The jury comes back tomorrow. Stay with us. We'll have more Karen Reed coverage up next.
Call or go online to helpfighthate.org today.
That's Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today bringing you your front row seat to justice.
The fate of defendant Karen Reed remains in the hands of a jury. We are in Dedham, Massachusetts for verdict watch in Reed's murder retrial. She is accused, of course, of killing her Boston police officer boyfriend, John O'Keefe.
And we just found out that the jury is, in fact, going home for the day.
I am surprised. Let's bring in Court TV crime and justice correspondent Matt Johnson, who is live outside the courthouse. Hello, Matt. Tell us the latest, your thoughts as we learned they're going home and coming back tomorrow.
Now, I know a lot of people are surprised. Not so much. Now, when we heard all of the movement coming back to the courthouse here earlier today, it's because, all of the parties needed to be present as soon as Judge Beverly Cannone had a note pushed back to the jury room to ask them if they wanted to work late. Yes, that's surprising that they didn't want to work late today on the second full day of deliberations, 3 days total. Right now, we're waiting for this defendant along with her defense attorneys to leave the courthouse. They're going to be exiting right here just in a few minutes. But I think what is surprising to so many is those questions that were so early in the day and very specific pointed questions about OUI and lesser charges and things of that nature and how much weight to put on certain evidence such as Karen Reed's statements outside of the courthouse with various media outlets. I've asked Karen Reed about that many times and whether or not she was going to testify after she decided not to testify and take the stand in her own defense, which would have been an opportunity for her to explain the context of those particular clips. She said that this jury has heard from her enough and that she actually feels very confident in this jury that she helped select in this entire process. Right now, what one of these officers is doing, the sergeant, they're always telling us, reminding us to let all the parties come through. That indicates that any moment, Karen Reed, along with her defense attorneys, they're going to be walking down these steps here in Dedham. And here they come. Again, all the attorneys remain under a gag order. They can't answer any sort of question. Karen Reed has been making hand signals, the peace sign and love sign to her supporters each and every day as we've been in this deliberation process. We'll see if she answers any questions right now. Are you going to be able to sleep tonight, Karen? Just a smile. She hasn't answered any questions all day during this deliberation process. She's walking very quickly to her SUVs as they wrap up a third day of deliberations here in Dedham. Everyone will be back here at the courthouse 9 a.m. bright and early tomorrow morning, and we'll see if we end up with an early verdict. This whole community on pins and needles, and aside from the media scuffling around this defendant making her way to her vehicle, it is completely silent here. I'll send it back to you guys.
Yeah, Matt, it's interesting. I know here in our studios, we were just so tight with anticipation that this was going to be something more. When it turned out that the jury was just going home, did you get a sense of deflation out there with the folks, for disappointment, I'll call it?
I think so, and I think that there was a bit of that yesterday as well. I think that all of the supporters here had hoped for an early verdict, and quite frankly, this defense team in trial number one, if you watch the ID documentary, it shows some slices of video when they're waiting for that verdict watch last year in 2024. And you can show that they were disappointed and they were nervous after it went past one day. And I could be, it may have been the second day or something, but I know that all of these supporters in this defense team was initially disappointed that it wasn't a straightforward verdict and right away last year, and I'm getting that sense this year too.
And as we're watching this unfold, we know they come back at 9 a.m. in the morning. Remind us, what is the normal process when the jury comes back at 9 a.m.? Does Judge Cannone expect the defense team and the prosecution to be there at 9 a.m. as well, Matt?
Yeah, she wants all parties front and center, ready to go. And then when she brings in the jury, she's going to be asking them those questions. Have you seen anything? Have you heard anything? And so far, this jury has not answered that they have noticed anything in social media or anything on the television. And quite frankly, it's hard to avoid this case. Every time I turn on the TV in my local hotel room, this case is on, or they're advertising coverage of this case. You go to the grocery store, every single newspaper has pictures of this case and headlines. It's very difficult to avoid this case in this tight-knit and small community.
Matt, we've talked a lot about, the proliferation of this case in the community. We know that the jurors are from the community, and the court does the best it can to shield them from any of this. Do you get any sense in terms of where they come in and come out, and whether they're aware that there are people outside? I mean, they've done a fantastic job of keeping quiet, not making noise, not infiltrating the courtroom in that way. But just their presence alone, do you think this jury has a sense of that is what's going on outside?
I think that they do. I do know that it is quiet outside the courthouse when they're deliberating. It's much more noisy with the fire trucks that roar past and all of the construction crews that go on the roads in front of the courthouse each and every day than how these supporters have been acting, or any noise that they're making. As for the jurors, sure, I'm probably sure that they realize that something's happening in front of the courthouse, but they are bused here to this location. They are escorted in. They are brought in through a different door. They do not pass the front of the courthouse here. And that's pretty much all I'm going to share about that, because I'm sure that, for security reasons, they don't want us to get into detail.
Sure, absolutely. Let me ask you this, Matt, because we know that there were 3 jury questions that the judge responded to, and then there was a break. And at 1:30, everyone expected the attorneys to be back in court. They were. We went in, and that's when we learned there was a 4th question. And it was one to which she said they wanted to know, basically, could it be a split verdict? Because they were asking, if there are 2 not guilties, can we then do something different on the 3rd charge? And her response was, that's a hypothetical. I really cannot give them any guidance on that. I can't answer that question. Tell us about the vibe and the feel with, first of all, the 3 jury questions, but then everybody having to come back at 1:30 and then learning there was a 4th question.
Right. The other questions being, number one, what was the time frame for the OUI, which is basically DUI in the Commonwealth, charge at 12:45 or 5 a.m.? Question 2, are video clips of Karen Reed's interviews evidence, and how can we consider them? Question number 3, does convicting guilty on a subcharge offense, number 2, number 5, convict the overall charge? So, these were the questions before you got to that point at the 1:30 mark, and before everyone had to come back to the courthouse here. But I think that a lot of people were speculating that there could have been a verdict at that point in time, and there wasn't. And it led us to thinking that there might be one by the end of the day, and here we are. At the end of the day, we're going to head into a 4th day of verdict watch.
It really leads me to believe, Judge, and you can ring in on this, the idea that we thought, at least the way the questions were structured and the way they came out, that maybe they were just really stuck on the OUI charge. They had sort of passed through the others and were getting on that OUI charge. Matt, just your thoughts on this. My feeling is, had it been just the OUI charge that they were stuck on, and perhaps whether she was OUI at 5 in the morning or at 12:45 at night, 12:30 at night, etc., we would have had a verdict by now. I think the fact that it's gone on this long after that 4th question means that maybe there's more going on in that room than we are speculating.
Well, there could be or there couldn't be, right? We don't officially know, and we won't until we do have a verdict and if someone is willing to talk. The first jury that deliberated, their names are still under seal. Their names have never officially been released. So, at this point, it's all speculation and conjecture, but, they may be still discussing a few things as opposed with the OUI question, and that's where we very well may be in a situation where it's an early verdict tomorrow morning.
So the first trial, and we know you covered the first trial, the second trial in its entirety. You've been inside the courtroom, outside the courtroom. You have been all things Karen Read. And my recollection is, I know that the first trial, they deliberated 5 days. I believe it was about 26 hours of deliberation. Now we're on 3 days, moving into 4 days tomorrow. 15 hours, 24 minutes they've been deliberating. What do you think of that difference? I mean, in the feel of the first trial versus the second, we know there were a lot of pivots, and it was a very different trial this second time around.
Yeah, well, I love comparing the two trials because they are just so night and day. There's such a contrast between the two. I mean, there was something like 90 witnesses, or, you know, I could be getting the number wrong, from the first trial, and it spanned a few more weeks. That was a trial that was 10 weeks total of testimony. This was 8. This prosecution rather, was much more precise in who they were calling and why they were calling them. And, you know, I just think that it's just a completely different trial from the viewpoint of the deliberating jurors, because they don't get to see all the sidebars. They don't get to see all of this stuff that's happening in the news or outside the courthouse. They don't get to see all of the motions for this and that. They're in that jury room, and they're in that courtroom when there is case evidence.
And Michael, I just have to ask, now it's off screen, but there was a person in a pink shirt, a big dog in a pink you know, harness, whatever that was on that dog. And you have to wonder, is that coincidence, or is it at all speaking to the fact that there's that whole argument of dog marks on John O'Keefe?
Well, the person probably just has a dog and decided. I don't think it's a coincidence that the dog was in pink. The fact that they were walking a dog by the courthouse, I don't think it has anything to do with Chloe. Maybe it was Chloe.
Lean in.
I'm trying. It may or may
just
not
stood out to me.
Been. No, and again, that I think really shows, Matt, and you can speak to this, truly the amount of support that Karen Read has in the community. It's really been something Vinny's spoken on, you've spoken on it. In cases like this, it's so rare for a defendant to have this kind of support, but yet here in Canton, and I guess because of some of the history, we know a little bit about some of the issues there, that this community really has come out in support of Karen Read.
Well, I think that's, what you're seeing in the numbers of supporters in the first trial, and then what's been growing in this second trial. You've seen the video. It doesn't really encapsulate what's really happening here, and the numbers of supporters that we've seen. I mean, what you see on TV, it's actually bigger in person, probably.
And if you look right now, Matt, we can see it is cleared out. We have been watching with you, with Vinny, down in the throngs of people. It looks like once it was known that the jury was going home to come back in the morning at 9 a.m. to continue deliberations on day 4, it looks like people left.
Yeah, I mean, and that's what we saw yesterday, and that's what we're seeing again today. Especially the weather has something that plays into that, right? Like it's really starting to rain and come down very hard right now, so everyone's kind of getting out of town. But we did see the crowd just kind of get smaller, and everyone went home right away yesterday when we knew that we weren't going to have a verdict yesterday. Almost like at the end of a fireworks show or the end of a parade. That's how quickly people are getting to their cars and trying to get out of traffic.
And that's what it reminded me of, Michael, a parade. As we were watching and the people were leaning forward, standing up, getting ready for those big black SUVs to show up, it felt like we were watching a parade to me.
Yeah, and there had to be a profound sense. And there goes that dog again.
Yes, look at that, it's a big dog.
The pink outfit on. Yeah, there had to be a profound sense of disappointment because I think everyone expected something more rather than just a note that they wanted to go home or to be sent home a little early today. But I know they'll be back in full throng tomorrow, expecting something relatively early, because I know that's kind of where I am. And when I came in and I came on the set, you expressed to me how deflated you were.
Yes,
I mean, we're human beings, right? We're
yes.
here, we were up, and you're up emotionally.
Yes,
you're
and
doing
the
your
energy.
coverage and expecting something to happen, and yet it doesn't.
Yeah, because I bought into the energy that was being portrayed as outside that courthouse,
Sure.
and I think everyone was hopeful it was a verdict, so I leaned into that, and it's exhausting. You cannot imagine what it's like for John O'Keefe's family, for Karen Read and her family, for the attorneys on both sides. This is a lot of stress on any of those individuals.
Actually, and that's great for you to say it, because if you feel that, imagine what they feel.
Yeah, absolutely. All right, we're going to take a break, but of course, we're going to continue to bring all of our great coverage regarding Karen Reed and her murder retrial. We'll be right back.
Brutal murders of 4 University of Idaho students.
Oh my God, this doesn't happen here.
Detectives arrested 28-year-old Brian Kohlberger.
You could tell there was some off about him.
He was stalking them. He was hunting them.
Forget about motive. We don't even have a connection.
This trial will be on Court TV.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.